Good morning, ladies and gentlemen. Thank you so much for joining us for the CDH Employment Law Annual Webinar focusing on the changing work order. I'm Avinash Govindjee, and it's my great pleasure to facilitate today's session. COVID-19 has certainly dominated the landscape over the past 6 months, with massive concerns arising regarding the projected rise in unemployment and increase in business rescue and retrenchment processes. In the midst of health and safety in the workplace and other conduct occasioned by the pandemic, the courts have continued delivering judgments on a range of so-called normal matters, collective and individual employment law, strikes, and business transfers. Our distinguished speakers, all from the employment practice at CDH, will address a selection of these issues during the next few hours, COVID-related or otherwise, also unpacking some recent statutory developments relevant to labour law. While the focus is on all these developments, it is significant to note the renewed importance of some basic principles and concepts such as force majeure and termination of contracts due to supervening impossibility of performance, which will also be discussed and clarified. We hope that you will benefit from the Case Law Update booklet, now in its 7th edition, that will be made available to you, together with the slide presentations. We will also distribute. With all the uncertainty currently in the labour market, even after the President's announcements last night, we present this webinar to you in an attempt to provide some much needed clarity. Please feel free to type in any questions you might have using the chat box feature of this event, and our speakers will address as many of these as possible during the course of the webinar. We encourage you to pose those questions as they arise during the presentations and not to wait for each Q&A session to do so, to give our speakers a chance to consider their responses. Colleagues from the employment practice will also answer and publish any questions that are not addressed by the speakers during their sessions. So please keep a lookout for all of that in the chat box of the event, and don't be concerned if a particular speaker does not have time to address your question while making their inputs. We hope you will enjoy the morning with us and that we don't suffer any power cuts from the different parts of the. If there are any technical difficulties experienced, then we'll do our best to run the event as seamlessly as possible. There will be 2 short comfort breaks during the morning to give you a chance to stretch and grab a cup of coffee while you listen to our speakers. We trust that you will find their presentations to be interesting, informative, and beneficial to your own employment context. This is ultimately what motivates our preparation and the material we have chosen to share with you today. Our first session focuses on collective labour law, specifically collective bargaining, organisational rights, and majoritarianism. Fiona Lepan is a director in our employment practice. She has extensive experience in the field of employee relations, both from a litigation perspective and in terms of strategic planning. Fiona's sector specialities include employment litigation, individual labour law, collective bargaining law, and occupational health and safety in mining. Our employment practice. He has experience in areas including general litigation, dispute resolution, all aspects of competition law and employment law. Over to you, Fiona and Becky.
Thank you very much indeed. I'd like to start off by taking you through the important decision of the Constitutional Court in Amku and Royal Bafokeng, which is a platinum mine in the Northwest Province. Back in 2015, RETRENCHMENTS, which is the other name for this mine, needed to engage in a large-scale restructuring exercise. It had in place a collective agreement with the NUM and UASA, where they were the chosen parties for the purposes of the consultation process, to the exclusion of minority unions. Now, importantly, that fits within what we call the hierarchy of consulting parties, which is enshrined in section 189(1) of the LRA. You will know that the first consulting party are those with whom the employer may have agreed to engage in terms of a collective agreement, which is the case here. If that was not the case, one would need to look at whether there was a workplace forum, because that would require the employer to follow that particular prescript. In the absence of a collective agreement or workplace forum, you will know that one needs to consult with the registered trade union at the workplace if there is one, failing which the employer would be required to engage and consult with the individual employees. Now, given that the collective agreement under section 189(1)(a) was in place, the employer needed to go no further, and it issued its notices to both UASA and to the NUM of its proposed restructuring and retrenchment process. This was a facilitated process as well, but importantly, AMCU was given no such notice. General notices were sent out across the workplace to all employees, advising them of this process commencing. That became a point of controversy, but ultimately the Constitutional Court found that everybody was aware this process was to take place. Importantly, what AMCU then got very upset about when several of its members in a group of 103 were retrenched, and they literally arrived at AMCU's doors and said, "We've lost our jobs. We tried to report for duty, but we were told we'd already been retrenched," is the following. It said, look, this exclusion of ourselves to represent our members in the resulting consultative process influences and impacts our constitutional rights to freedom of association and, importantly, fair labour practices. And what AMCU sought to do was have this hierarchy of consulting parties struck out from the LRA. There was a further collective agreement entered into between the employer and UASA and the NUM, which regulated the entire mechanics of the retrenchment process, including the selection criteria and how that would be applied, the severance package that would be available, and assistance to those who would face retrenchment. And of course, that agreement was extended to non-parties, in particular to non-unionised employees and employees of minority unions, by virtue of what we call the extension provision, which you find in section 23(1)(d) of the LRA. And who challenged that particular provision to say that in view of the fact that the consultative process had excluded both it and its members, there should be a reading into section 23(1)(d) to say that collective agreements cannot be extended if they deal with the retrenchment of those that were not part of that process. With that in mind, one has to also examine another angle to AMCU's challenge, which was that in disciplinary matters, for example, in disciplinary inquiries, in incapacity hearings for poor performance or incapacity, employees have a right to choose their preferred representative. And if there's a registered union at the workplace, to have the union come and assist them through its representatives that are available. And that is not available to them if there is a retrenchment process. And AMCU argued that its members were thus excluded from this right, based ultimately on their union affiliation. And that was the net effect of this hierarchy of consultation or consulting parties that one finds in section 189(1), as I have said. But what AMCU was really upset about also, and it made quite an issue of this, is that our legislation is not compliant with the Convention of the International Labour Organization number 98, which deals with a right to organize and collective bargaining. And what that ILO convention states is that you cannot subject an employee to a condition that could make him relinquish his chosen trade union affiliation. And effectively, the section 189 with 23(1)(d) was achieving exactly that problem. Now, the other important factor is this. The LAC, and both the Labour Court and the LAC were strident on this aspect. They said, look, retrenchments do apply across workplaces, and that's the distinction between individual disciplinary or incapacity matters and a retrenchment consultative process, because the consultation process can ultimately result in a collective process with collective outcomes, and that was really what the LRA sought to do in order to ensure that there would be industrial peace. After all, Section 189 is in its own right a manifestation of a policy choice by the legislature, which is that it favours and it supports the policy of majoritarianism. The union gets a seat at a consultative table, not based on its right simply by virtue of it having members at the workplace, but by virtue of the union's statistical dominance in the workplace. What became the argument is that individual employees have got little clout in a process like this. You need strong, dominant unions to be able to place pressure on the employer to come up with better benefits and protections for employees as a result of consultation. Where did the Constitutional Court land on this point? It said that Section 189 did not limit the constitutional right to fair labour practices, because that right does not and is not guaranteed in a retrenchment exercise. It said that the statutory requirement for consultation flows from the LRA. It's not embedded in the Bill of Rights. And it found that there was no implication here to Section 189. It's the policy choice. It's been enshrined in our jurisprudence for the last 20 years, and there's no reason to strike it down. Also, in relation to this issue of a right not to be unfairly dismissed, again, said the Constitutional Court, that's sourced in the LRA. It's not a constitutional right. And as a consequence, that did not mean that the dismissals that resulted were unfair. But what about the employee that is not a union member, or it was in this instance a member of AMCU, and it believed it had been unfairly dismissed at the end of this process? The Constitutional Court said, look, there's no unfairness at play, and if there is, then the employee is not without a remedy. They can have that challenge in the appropriate forum. The collective agreement regulating the actual retrenchments contained a full and final settlement clause. The Labour Court, the Labour Appeal Court, and the Constitutional Court indicated, well, that doesn't mean that a court can't look behind the collective agreement in interpreting whether there has been any unfairness of a substantive nature should such a dispute come before the Labour Court for adjudication down the line. So employees are not without a remedy. There is an aspect of this case that was never ever explored, and that is the following. If Baden-Bok, which is a different decision of the Constitutional Court, allows a minority union to call for shop stewards as part of a campaign for the securing of organisational rights, if it's allowed to strike on that point, which was the decision of the Constitutional Court all those years back, then why is it not possible for a minority union at a given stage to say to an employer, I want to bargain for those rights and I want to strike? If it had the clout in terms of numbers, it might be able to make its presence felt at the workplace, but that's an issue that was not explored. In the minority decision of the Constitutional Court, those judges were most concerned about this inability on the part of AMCU's members to actually have a say in the pre-retrenchment process, and they found that that had to implicate the issue of equality, and that's where they set themselves aside from the majority judgment. This is a finely balanced court that was literally 5 judges to 4. So it tells you there's a great tension between this policy consideration of majoritarianism that our LRA certainly endorses, and which has been the landscape of our law for some time, And if you're going to allow, as the Labour Appeal Court said, a tugging of the thread of majoritarianism with regard to consulting partners, you might unravel the entire sweater woven by the legislature in the LRA. Just before I close, I'd like to mention that there's hot off the press a decision with regard to sympathy strikes by the Labour Appeal Court that we had the privilege to have been involved in, where the Labour Appeal Court has come up against and very stridently in saying, do not bring a matter before me where you're looking for advice on the application of legal principle. You come with a live dispute, or you do not have the opportunity to ventilate your issue before this forum. It's a very important case on the issue of mootness. Thank you very much. I would like to hand over to my senior associate, Becky Nhlapo, who's going to take us further into some very interesting insights in this field of collective bargaining. Thank you.
Morning, everyone. I will be dealing with two cases, and the first case that I'll be focusing on is the, if you may just turn on the next slide. The first case I'll be focusing on is the King Hire case, and the importance of this case is the employer's right to use a lockout as a bargaining tool in terms of collective bargaining. And what we have seen in practice is that employers would normally wait until there's a strike action for them to institute a lockout. And this case raises a very interesting aspect in terms of the use of the lockout. And what happened in this case was simply that there was a dispute of mutual interest which related to the 13th check, which the union referred to the CCMA. This dispute at the CCMA remained unresolved, and the union issued a strike notice. However, the employer approached the High Court for some reason, for the picketing rules. And there was an interim order there. And in response to the interim order, the employer decided that, well, in fact, what happened was the union decided that it will suspend the strike notice that they initially issued. And in response to the suspension of the strike notice, the employer instituted a lockout. And what happened next was that the employees reported for work and they found that they had been locked out. What was interesting is that the union challenged the lockout on the basis that it was unlawful. And the reason for that allegation was that since the strike action had been suspended by the union, the employer had no right to continue with the lockout. And that was really the question before the Labour Court, which was, in the absence of a strike action, can an employer continue with a lockout? Can a lockout be deemed to be lawful where there is no strike action? And the Labour Court made interesting findings on this specific aspect and said that the lockout is a bargaining tool to be used by the employer and is available by the employer. And the only condition necessary for such a right or tool to be used by the employer is that there must be an underlying dispute which is unresolved. In this case, the dispute of the 13th check, which was referred to the CCMA by the union, was still unresolved, and the only way in which the parties could resolve this dispute was through either an agreement or through the power play in collective bargaining. What was also important in terms of the findings by the Labour Court was that the Labour Court recognized that to interfere with the employer's lockout would really be interfering with the collective bargaining tool, which an employer can use at any time. And most importantly, in dealing with the allegation by the union that since the suspension of the strike notice, the lockout was unlawful. The Labour Court said that the suspension of the strike notice did not render the lockout unlawful because the underlying dispute remained unresolved. What is also interesting to note in this case is that even if the strike notice had been withdrawn by the union, it is likely that the court would have found would have reached the same conclusion, that given that the underlying dispute had, or rather remained unresolved, the employer was entitled to lock out the employees. And it is interesting to note that the lockout lasted, I think, for more than 4 months or so, and the employees eventually agreed with the to the demands of the employer. Just moving on to the next case, which aligns with the RETRENCHMENT decision, which Fiona dealt with. And the principle in this case is really, and aligns with the RETRENCHMENT decision, that orderly collective bargaining should be the way to go, and in fact is the way to go. In this case, simply, or rather the facts of this case were that NUMSA had attempted to recruit membership from Lufil, and we know that NUMSA operates in the metal and related industries, and Lufil was, in fact, is a paper and packaging company. And when the NUMSA approached Lufil, Lufil's response was that in terms of NUMSA's constitution, the class of membership only was limited to industries in the metal and related industries, and therefore refused granting the rights, organizational rights, such as your membership subscriptions. What happened next was that NUMSA referred the dispute to the CCMA. The CCMA found in favor of NUMSA and granted the rights in terms of the organizational rights in favor of NUMSA. The company reviewed the decision at the Labour Court. The Labour Court found that the inquiry in terms of the constitution was a private matter, and therefore the company could not inquire and hold NUMSA accountable in terms of its constitution. The Labour Court dismissed Lufil's review of the CCMA award. The company approached the Labour Appeal Court to appeal the Labour Court decision. The Labour Appeal Court found in favor of the company and said that the Constitution is a document which outsiders can inspect, and therefore the company was entitled to inquire and hold NUMSA accountable in accordance with its own constitution. And since the constitution, or NUMSA's constitution, said that the scope within which it will recruit and operate was the metal and related industries, NUMSA had no right to recruit outside this class, and therefore granted the appeal and reversed the arbitration award. Subsequent to the Labour Appeal Court, NUMSA approached the Constitutional Court and alleged that this matter involved the right to fair labour practice, the right to freedom of association, and the Constitutional Court made the following finding in respect of these issues, and said that a union's constitution is a binding document, and if a union's constitution states that the union is only allowed to recruit within a class of employees and industries, the union is bound by that document. And I think that's a very important finding by the Court, in that although a constitution of a union's constitution is a private document, outsiders are entitled to inquire into it and hold the union accountable. What is more important from this case is that the Court made the finding that it is necessary. It made the finding that the recruiting within a class of members that are set out in the Constitution is important, and it is necessary to ensure an orderly collective bargaining in our at sectoral level. And I think I'll just leave it at that as the stage from our collective bargaining contribution.
Thank you very much. Thank you very much, Fiona and Becky. And we've received an interesting question about the hierarchy of consulting parties that Fiona will respond to. And I think your presentations also touch on some interesting broader questions that I'd be interested to your views on. And the one is really industrial peace post-COVID. We've seen political parties, interest groups starting to question the timing of retrenchments post-COVID and whether the law should be changed in that regard. And also one wonders what's going to happen with salary disputes. Are negotiations going to be smoother now thanks to COVID? Is it going to be easier to sign longer collective agreements? It'll be interesting to get your thoughts on some of those issues. I'll hand back to you, Fiona, and then Becky. Thank you.
Thank you. A pertinent question put to me is if there is no collective agreement, but there is a trade union that's registered with members at the workplace, would the employer be required to consult with that union? And the answer is yes. Again, hierarchy, I have to assume that not only is there no collective arrangement such as you saw in the Bafokeng-Rasimoni case, and no workplace forum, because that then brings you to whether or not there's a registered trade union with members or more than one. And of course, the important point is in that scenario, that registered trade union or unions may have a handful of members, might not be dominance. So you would be obliged to consult with them and not leave them out of that consultative process. And there's independent case law supporting that aspect too, because sometimes employers have a difficulty. They say, we didn't know there was such a trade union present at our workplace or had members. And if it makes its presence felt, then an employer has to see how best to deal with that, because the process might have run its course. In which case, if the employer was unaware, it cannot be faulted if it did not, in fact, engage with that party.
I think on the question on collective bargaining post COVID-19, I think we'll see a lot of companies trying to align themselves with the lessons from COVID-19. And one of the lessons was the manner in which you consult and whether or not we'll see consultations via Zoom and via Team, would those continue? Because those have been recognized by the courts as to be valid alternatives under COVID-19. We may see those obviously still continuing post-COVID-19, but on the substance, I think we will see a lot of companies trying to take the lessons and prepare themselves for a new workplace post-COVID-19, and obviously to be able to deal with lessons that were sort of learned under COVID-19, such as your workplace plans, such as being ready for similar incidences. I think it will also be good for business if companies are able to tighten their belts and operate at a level where they are able to revive their businesses. So I think it will be an interesting atmosphere under post-COVID-19.
Avinash, if I may, in closing, there are two questions that have been posed which talk directly to the issue of strike ballot provisions and, of course, the important decision of the Labour Appeal Court in NUMSA and Male Bear and Fosco. We don't want to answer those questions right now because it's going to be the subject of Hugo Pina's team's talk on the issues with regard to strikes and lockout. So we're not avoiding answering the question, it's just coming up in a different sequence. Thank you.
Thanks very much, Fiona. So, I mean, interesting responses. And Becky, you talk about some of the technological requirements, and you also start seeing opportunist litigants trying to avoid processes because of perceived technological challenges. And we've already seen at least one judgment which is coming down on that and saying you've got to be careful before you decide to avoid participating in processes, consultative processes, in order to just simply delay retrenchment. So it'll be interesting to see how the law develops now as we see more cases in relation to COVID and its aftermath. Mr. Jose George is a director in our employment practice based in Cape Town. He specializes in employment litigation, individual employment law, collective labor law, and general employment law. Jose has specialized in this field for nearly 20 years and will now highlight some of the pitfalls associated with retrenchments, a crucial topic given the current landscape. Over to you, Jose.
Thanks, Avinash, and good morning, everyone. Karishka, if you can go to slide 1. So what we do know is that our economy is in deep trouble. If you have a look at this slide, what it shows you is the official unemployment rates. So the current slide is where we are at the moment. Bear in mind our total working population, that's the entire pie, is 23.5 million. So at the moment, 7 million of those 23.5 are unemployed. What's quite concerning about the current slide is if you look at that percentage underneath, 63.3% of the unemployed is in a relatively young age group. That's the 15 to 37 age group. What's even more concerning is if you look at the expanded unemployment rate, so this includes people who've actually stopped looking for jobs, that rate is 43.4%. So we currently are not in a very good situation. If you look on the right, those are projections by Treasury. The situation looks bleaker. So the worst case scenario, another 5.6 million job losses, that's if the economy recovers very slowly. The Organization for Economic Cooperation and Development predicted in June that the economy would shrink by another 7.5%. This morning, they've updated that figure to 11.5%. So it's a vicious circle. What we've got is a weaker GDP. This means weaker tax revenue. That means greater budgetary deficits, more lending, financing the debt, and the cycle repeats itself. Karishka, if you can move on to slide 2. What we know that is when the economy is down and things get tough, that companies have to tighten their belts, and inevitably this leads to job cuts. So what you see in the slide before you now is the number of retrenchments that were referred to, or retrenchment disputes that were referred to the CCMA in a 3-month period from 1 April 2020 to 30 June 2020. So you'll see just normal retrenchments, 1,676 retrenchments in 3 months. I mean, this is unprecedented. And then the larger scale retrenchments, you'll see that there are 362 of them. And that's a concerning figure because that applies to employers who employ more than 50 employees. What that slide doesn't tell you is that the total number of affected employees is over 101,000 employees. So, you know, we're losing jobs at a massive rate. What the slide also doesn't tell you is that we've cut the CCMA's budget by 55 million for the coming year. So, to put it mildly, things are looking very bleak. Karishka, if you can move to the next slide. So we all know that the LRA sets out stringent procedures that have to be followed if you intend retrenching your staff. And we know that these are contained in section 189 and section 189A of the Act. What I've been asked to talk about today is some of the potential pitfalls or things to be careful about when you're involved in a retrenchment process. I've looked at my own experience in my own practice, and I hope to provide you with some insight into some of the pitfalls that I've identified and make you aware of them so that potentially you can avoid them if you're forced to contemplate retrenchments. If you look at the slide, these are the 3 potential pitfalls I've identified. The first one is, when do you start your consultation process? To use the language of the Act, when does contemplation arise? The second thing I'll talk about is the interplay between automatically unfair dismissals, that's section 1871C of the Act, and the interplay with section 189, which is your retrenchment provisions. And we're seeing more and more of these types of disputes arise where employees refuse to accept a demand that arises in a operational requirements dismissal that relates to a matter of mutual interest. And then the last issue I'll talk about is the timing of when you can give notice of termination where there's been no facilitation in a large-scale retrenchment. If I do have time, I'll look at some of the more novel retrenchment cases that have arisen in 2020. These cases are in the case law handbook, so if I can't get to them, you're not going to miss out on anything. So to go to the first issue, when does the obligation to consultation arise, or to consult arise rather? So when you pull the trigger on the consultation process is a complicated issue. You'll understand that employers are reluctant to pull that trigger too early because there's a quite rational fear that this process is going to destabilize the company. So news of retrenchment's extremely distressing to employees. It's demoralizing, it'll lead to lower productivity, and worse, there's a fear that skilled staff will jump ship as soon as they know that the ship is sinking. So why is it important to get your timing right? Because if you don't, and you start your consultations too late, then you run the risk of a finding that you've presented the employees with a fait accompli and that you haven't allowed for meaningful consultation. And the consequence of that is a finding of substantive unfairness and a possible reinstatement order. And depending on the number of employees that have been retrenched, this can be a very expensive and obviously detrimental exercise for the business. So I just want to look at where this contemplation arises. So it comes from section 1891, and what that section requires is that when you contemplate dismissing one or more employees, that you must consult with the affected parties. So we know what the issues for consultation are. You've got to consult about the appropriate measures, and that's to avoid or minimize the dismissals, how you can change the timing, mitigate the adverse effects. Then you have to consult about the selection criteria and the severance pay. So determining when contemplation arises can be difficult, and it was a relatively vexed legal question until recently. And the Labour Appeal Court has thankfully come to our assistance. And what it's made clear is that contemplation doesn't arise when an employer is considering its options. So you're entitled to take a provisional decision to consider possible retrenchments without consultation, but you're not allowed to make the final decision before you've consulted with the trade unions and the employees involved. So in practice, what that means is you can make a decision in principle to retrench before you start consulting. The LAC has also clarified that where an employer is considering ways to avoid retrenchments and it's evaluating the pros and cons of these measures, that it's not obliged to consult. And the reasoning is because at this stage, the objective isn't consensus seeking, but rather to look at alternatives to retrenchment. And if none of the alternatives is viable, only then does the employer take a firm view on dismissal, and only then is it obliged to consult. So you're not prohibited from investigating a plan without consultation, and contemplation doesn't arise when you're initially considering the alternatives. It's only once the alternatives are discounted and you're considering dismissal, only then do you have to consult. So this is also supported by section 1893B of the Act, which requires that you disclose in writing the alternatives which you've considered prior to commencing the consultation process and the reasons for rejecting each of those alternatives. So it's clear from the case law that contemplation arises not on the possibility of retrenchment, but rather once dismissal is identified as the preferred or most likely option. However, the caveat is that you must still remain sufficiently flexible to conduct meaningful discussions with your employees, and you mustn't present them with a fait accompli. Then moving on to the next issue, the automatically unfair dismissals. We spoke about that earlier. And this is the interplay between section 1871C and section 189 of the LRA. So quite often in a business, one of the ways that you can ensure productivity and you can avoid job losses is to effect a change to terms and conditions of employment. Now, this is very controversial. You see this quite often. Employers maybe want to change a shift pattern, or they want to change the duties that the employees do just to make the business more efficient. And you'd think that if you're able to preserve jobs, that this would be laudable. However, if you do change terms and conditions of employment to save jobs, you run the risk of an automatically unfair dismissal. So I just want to look at section 1871C. So what the section provides is that a dismissal is automatically unfair if the reason is a refusal by the employees to accept a demand in respect of any matter of mutual interest between them and their employer. So you need a reason, a refusal, a demand, and it must be a matter of mutual interest. So I don't have to explain the risks to you of a finding of an automatically unfair dismissal. So the limits on compensation are immediately doubled to 24 months remuneration per employee. And if you get this wrong, it can obviously be a very expensive exercise. So this matter arose in NUMSA versus Avinash Trident Steel. It's a matter that was heard by the LAC last year, but it's quite a pertinent case. The facts of the matter are that the steel industry has been in decline since 2010, and by 2014, Avinash couldn't sustain its cost structure. So to survive or to remain viable, it needed to restructure its operations. So what it did is it initiated a consultation process with NUMSA, and they proposed a number of options. I'm not going to go through all of them, but it included a review of the structures. For current purposes, what's important is they looked at redefining some of the job descriptions. And then they also looked at the normal kinds of things like reviewing fixed term contracts, reviewing benefits, and they also allowed for the application for VSPs. Because what Avinash realized is that they weren't going to achieve what they needed just simply by reducing staff numbers. What they needed to do as well was improve productivity, and the one way they could do this was by changing the job descriptions. And the reason for that is because historically they had a very rigid and costly kind of division of labor. So as an example, a GA or general assistant only did work that fell within their portfolio. And similarly, a packer would only do what a packer does. And these aren't very complicated jobs, and either could cover for the other. But because there was no flexibility built into the system, they did limited work and they got paid in full for that. So what Avinash proposed was combining functions. So things that were previously performed separately, like the GA and the packer, could go into a single job description. So the packer would do what the GA could do and vice versa. And this was one of the issues in the whole consultation package. While they were consulting, they entered into an interim agreement with NUMSA, where this flexibility was temporarily introduced, and they paid a premium for that. They increased the hourly pay rate for these guys by 60 cents an hour. And in the meantime, the restructuring process continued, the consultations continued, fixed term contracts were done away with, a number of employees took VSPs. So you can see what's happened now is the workforce is contracting. And in this context, it now becomes important that Avinash has this flexibility that they've introduced in the interim agreement. So 2 weeks before the expiry of the interim agreement, NUMSA tells Avinash that their members are no longer going to perform the additional duties. This obviously leaves Avinash in an invidious position, because they don't have the employees that normally could have picked up that slack, because they've stopped the fixed term contracts and some of them have taken VSPs. So it seems like a deliberate tactic by NUMSA to extract higher wages in the middle of a restructuring exercise, which is ironic considering that the whole purpose of the exercise is to save money. So they have Avinash over a barrel, and eventually they agreed to increase these rates by an additional 3 Rand an hour. Sometime after that, Avinash informs NUMSA that they've concluded the consultation process. It's now exhausted, and they're going to implement the redefined job descriptions, so this interim arrangement. And they offer the employees the new job descriptions, and if they refuse, obviously they're going to be retrenched. So here's the irony. None of these employees will be financially prejudiced if they accept the offer, and they'll all have jobs. However, as we've seen on numerous occasions, the employees refuse to accept the new terms and conditions of employment. Avinash retrenches them, and correctly it retrenches them without severance because they've refused a reasonable offer of alternative employment. So what happens is NUMSA rushes off to court, and it says the dismissals are automatically unfair because Avinash has contravened section 1871C. And the case is simple. Okay, the wording of 1871C is clear. It's a dismissal is automatically unfair where there's been a refusal to accept a demand in relation to a matter of mutual interest. So there are only three elements you need, they argue. Okay, a demand, a refusal, and a dismissal. Avinash, on the other hand, argues that the court has to establish what the real reason for the dismissal is. Is it a refusal to accept a demand, or is it a legitimate operational requirement? And what they argued is that the wording of section 1871C doesn't suggest that just because there's been a proposed change to terms and conditions that's been refused, that the reason for the dismissal is necessarily the refusal. So what they're arguing is you must go to the root cause for this. And it argued that the operational requirements of the employer can be impacted by the refusal, and hence the court must determine what the true reason for it is. And also what it pointed out is that NUMSA's argument would mean that an employer in a retrenchment process would not propose any changes to terms and conditions of employment, even if those could save jobs, because they'd fear facing an automatically unfair dismissal claim if these changes were rejected. So the court agreed with Avinash. Again, it found that the question of whether section 1871C is contravened depends on what the true reason for the dismissal is. And the existence of the refusal of a demand merely prompts a causation inquiry. So firstly, the court must determine factual causation, and the court must ask whether the dismissal would have occurred if the employees had not refused the demand. If the answer is yes, then that's fine, the dismissal is not automatically unfair. If, however, the answer is no, as in this case, then it doesn't immediately mean that the dismissal is automatically unfair. What you then move on to is the next question in the causation inquiry, and that is legal causation. Okay, namely, is the refusal the main or most likely cause of the dismissal? So what the court found here is that Avinash's proposal regarding the job descriptions was made in terms of section 1892 and 3, and this was intended to avoid or mitigate dismissals, or there were alternatives to dismissal in the context of the consultations over the retrenchments. And that the process Avinash had embarked on was not only to look for an agreement to change the terms and conditions of employment, but really to avoid dismissals. And that was the main reason for the dismissal of the employees. It was Avinash's operational requirements. So to me, what's clear from this case is that you have to be very careful when you embark on a retrenchment process that may involve a change to terms and conditions of employment. And you must ensure that the proposed change is properly conveyed as either an attempt to avoid dismissals or an alternative to dismissals. And your rationale has to be very carefully conveyed so that there's a clear link between the main reason or the proximate cause being an operational requirement and not a demand to accept a change to terms and conditions of employment. So you've got to be very careful, and even if you anticipate that there won't be any dismissals as a result of a change to terms and conditions of employment, it's possible that this change will be resisted and that there's going to be a challenge on the basis of 1871C. So if you do have something like that, be very careful to link it to an operational requirement. I'm running a bit short on time, so I'll just very quickly deal with the last pitfall that arises out of section 189A and whether you use facilitation or not. So one of the innovations that 189A introduced was CCMA facilitation, and then also it prescribed a certain period or a minimum period for consultation. So companies, for some reason, and a lot of our clients as well, seem reluctant to use CCMA facilitation. And the fear is that they'll give away control of the process if they involve the CCMA, and the process will be delayed and it'll become bogged down in technicalities. So this isn't necessarily a view I share, but the trick here is that where you use CCMA facilitation, the timing is very clear. Okay, it's a straight 60 days. The period, however, is less clear where there's no CCMA facilitation. So we look to section 189A8 for the timing there, and what it says is that if there's no facilitator appointed, then a party may not refer a dispute to the CCMA unless 30 days has lapsed from the date of the notice. And then also, once the periods mentioned in section 64(1)A have elapsed, only then can you give notice to terminate contracts of employment. So it's not exactly clear what this means. Okay, what is apparent is that there are 2 time periods that come into play. So it's the first 30 days, and then there's this period that's been referred to in section 64(1). So what 64(1) says is that an employee, or employees rather, can go on strike if there's been a referral to the CCMA and there's been a certificate of non-resolution or 30 days have passed since the referral date. So in terms of section 64(1), we have this additional 30-day time period that's been referred to, although section 189A8 doesn't specifically refer to a dispute being referred to the CCMA. But the matter's been clarified. The LAC in De Beers Group Services versus NUM has interpreted this to mean that the second time period requires a referral to the CCMA and then the passing of a further 30 days before you can give notice of termination of employment. And the courts held that if you don't reach consensus in that first 30-day period, then a dispute of interest automatically arises, and that dispute has to be referred to the CCMA. So the caveat here is make sure that you refer your dispute to the CCMA. The CCMA itself seems to be unaware of the fact that you should refer these disputes to it. But if you don't, it's going to cause a delay, and you may have to redo the whole termination process, and that'll set you back time-wise. And certainly if your business is bleeding, that's time that you can't afford. I see my time's run up. I won't be able to get to the cases, but if I can hand back to Riola.
Thank you, Jose. Good morning, everyone. My name is Riola Cock, and I'm the CDH Employment Practice Professional Support Lawyer. Part of my role is to find innovative and efficient ways for us to better service you. Our theme for this conference and for the year ahead is a changing work order. The introduction of artificial intelligence, and more recently and more dramatically, the global pandemic, has forced us to envisage a new way to work and envisage the workplace anew. It's forced us to interact with our colleagues in a new way and to find new ways to position ourselves as businesses in the market. But a changing work order does not only mean the way an entity relates to the production of goods and services for their clients. It also means a change to the internal working environment of an organization. And this includes the way we upskill, train, and empower our employees, and essentially demands that we think about learning and training our employees in a new way. In keeping with the theme of a changing work order, CDH has developed and continues to develop e-learning products to assist clients in the online training of employees in what we're calling the changing work order. We currently have the following products to provide assistance to you in this regard. The first product is an anti-sexual harassment training tool. It is an online tool that assists employees and employers in understanding what is sexual harassment in the workplace and the manner in which sexual harassment can either be mitigated and or reported. Now, the purpose of this tool is to really assist clients with their obligations in terms of the Employment Equity Act to train their employees with regards to sexual harassment. The training is approximately 20 minutes. It is interactive. It includes voiceovers, pictures, and is quite easily understandable, irrespective of the level of the employee. Coming now closer to our current context, we've also developed a COVID-19 health and safety tool, which assists you in complying with your obligations in terms of the Consolidated Health and Safety Directive that was issued by the Department of Employment and Labour on the 4th of June 2020. Now, in terms of the provisions of the consolidated directives, all employers are obliged to make known the contents of that directive to their employees. What the COVID-19 health and safety tool does is that it eliminates the work from your end. CDH has put together an entire training module on the consolidated directive, as well as various other health and safety protocols that are best practice in the workplace. Upon reopening, however, the training can also be used as an ongoing training tool to mitigate any risks of COVID-19 as the workplace continues to operate. While the country may have recently moved to level 1, we know that the virus is still going to continue to live with us for a time to come. Now, the benefits of e-learning are manifold. One of the things that it does allow, and like I said, in this age of social distancing and the frequency with which future pandemics will become prevalent, e-learning really allows employers to train employees while maintaining social distancing. It allows employees to do it in the comfort of their homes, even perhaps, and allows them to do it at a time that is convenient for them, as opposed to being forced into a training room with 500 other people. It also allows the employee to attend to the training at their own pace and in a way that suits their style of learning. It allows employers to comply with their statutory obligations in terms of various either statutes or directives that have been issued by the Department of Employment and Labour without using any internal resources to develop it. It is interactive, it is simple, and it is easy to understand, and it is designed to cater for employees at various levels. All our e-learnings also include a short assessment at the end, which allows you to really monitor and evaluate the effectiveness of the training. In order for employees to pass the training module, they have to reach at least 80%. In this way, an employer is at least able to track the performance of employees as well as the effectiveness of the training. If you would ever like a demonstration of the products, you're welcome to contact me, and more information on the e-learning will be provided during the breaks, as well as my contact details. We will now be going into our first break, which will be a duration of 10 minutes. This will allow you to stretch your legs, grab a cup of coffee as we continue with this session. Thank you for joining us, and we'll see you after the break.
Welcome back. We hope that you've all had a good break. Let's move to the next session. It's a great pleasure to introduce Gillian Lum, who is a director in our employment practice based in Cape Town. She has extensive experience in all aspects of employment law, including drafting contracts of employment and employee policies and procedures, furnishing advice on restructuring and retrenchments, on the employment law implications of the transfer of a business as a going concern, and conducting due diligence exercises from an employment law perspective. Mosina Chinya began her career in employment law in 1993 as an associate at PSN Attorneys. She was appointed as a director at the same firm in 1997 and joined CDH as a director in 2013, now practicing in our department as an executive consultant. Gillian and Mosina will now address the themes of individual labour law and business transfers.
Gillian, please unmute.
Okay.
Okay, you've gone on to mute again, Gillian.
Good morning, ladies and gentlemen. As Avinash said, I'm going to be talking about individual labour law, and what I've done is select 3 recent decisions of the Labour Appeal Court. The first decision is one which was issued out or handed down by the Labour Court in May of this year, and the other 2 decisions were handed down by the Labour Appeal Court in November last year. The first decision involves a change in an employee's terms and conditions of employment. The retirement age was reduced, and the employee alleged that the change was unilaterally imposed by the employer. The second judgment deals with dual claims, one before the Labour Court and one before the CCMA, and whether the employee was entitled to do that. And the third deals with the scope of Section 60 of the Employment Equity Act and the liability of an employer for racist comments made by a customer to an employee of the employer. So first off, dealing with Legal Aid South Africa versus Tennyson. This is a decision where the employer changed the retirement age from 65 to 60, and the employee alleged that the change was made unilaterally. He had initially signed a contract of employment which was silent on the retirement age, but the contract of employment did refer to an employee manual which applied to all employees, and that manual referred to a retirement age of 65. The employer, during the course of the employee's employment, consulted with the employees and the trade union to amend the retirement age and reduce it to 60 years of age. The employee was then held to the 60 years of age, and his employment came to an end when he turned 60. He then challenged that as a breach of his contract of employment, alleging that his employment had been unlawfully terminated, and he referred a dispute to the Labour Court. The Labour Court found that the employee's dismissal was premature, and the employee was reinstated. The employer, Legal Aid, then referred a dispute to the Labour Appeal Court, appealing the judgment of the Labour Court. And the Labour Appeal Court then needed to consider and interpret the terms and conditions of employment and the employee's contract of employment. And the Labour Court found that the employee's terms and conditions of employment had been amended by the employer and had been done so fairly, and the employee was held to the 60-year-old retirement age. But 2 important things come out of the judgment, and that's the reason why I've selected the judgment, is the issues relating to the consultation process and flexibility which the employer had built into the employee's contract of employment. So firstly, relating to the consultation process, Before making the change, the employer engaged in an extensive consultation process with the employees and the trade union. And what was significant is that throughout that process, the employee didn't object to the change in the retirement age, and he didn't carve out for himself a retirement age of 65, notwithstanding the change to the employee manual. So the employee was then found by the Labour Appeal Court not to have objected, and despite being involved in the consultation process, not to have rejected once again the change that was proposed by the employer. And the second significant issue was the element of flexibility which the employer built into the contract of employment and its employee manual. And what it specifically provided was that flexibility was an inherent requirement, and it recorded that it would consult with employees appropriately if there was a need to vary conditions of employment. And then significantly, in the employee's individual contract of employment, it provided that by signing the contract, the employee agreed to being flexible in adapting to change in his working conditions. And on that basis, the Labour Appeal Court found that the employer was empowered to make the change that it did do, and that it was contractually entitled to make that change. So two important lessons here is to obviously consult with employees adequately before you make a change, and also to build into your contracts of employment and your employee manuals wherever possible the element of flexibility, which weighed heavily in this case in favour of the employer in making the change after it consulted with the employees. If we can then change to the next slide, please. The next decision is Archer versus Public School involving Pinelands High School, and it's a decision handed down by the Labour Appeal Court in November of last year. And the question for determination by the Labour Appeal Court was not a novel question, but I think one that deserves reiteration. And it relates to whether an employee could refer a dispute to the Labour Court once the employee had unsuccessfully challenged an unfair dismissal dispute before the CCMA. Very briefly, the employee had been employed by Pinelands High School. The governing body elected to remove the employee from the workplace, and the employee then claimed that that was an unlawful removal, that the employer was the school and not the governing body, and that the governing body lacked the necessary authority to remove him. The employer also challenged the school's failure to reinstate him and to remedy the unlawful actions of the governing body. He then referred a dispute to the Labour Court relating to an unlawful breach of his contract of employment. And that he did after unsuccessfully pursuing a dispute before the CCMA, where he claimed unfair dismissal. What the Labour Court found was that it lacked jurisdiction to entertain the second dispute. The dispute referred to the Labour Court relating to an unlawful breach of contract of employment. And the court there relied upon a decision of the Labour Appeal Court in 2017 involving James and Eskom Holdings. In that decision, the employees had initially referred a dispute to the CCMA, claiming an unfair dismissal, and then, when they were unsuccessful, reviewed that decision before the Labour Court, claiming not that there had been a dismissal, but rather that there was not a dismissal. So they changed tack when they got to the Labour Court and argued something different from what they'd argued at the CCMA. And on that basis, the court said that they could not be taking that sort of action. They couldn't refer a second dispute to the Labour Court, where they were effectively abandoning the approach that they had adopted at the CCMA, where they'd said there had been a dismissal, but at the Labour Court they then argued that there had not been a valid dismissal. The Labour Appeal Court was then required to make a determination as to whether two disputes could be referred. The attorneys on behalf of legal aid argued that they couldn't refer a second dispute, arguing that there was forum shopping effectively being engaged upon by the employee, and that essentially he was preferring the same dispute to the Labour Court, which he'd referred to the CCMA, and that he was then precluded by res judicata from pursuing the second dispute. What the Labour Appeal Court then did was confirm that an employee could in fact refer two disputes. They have a common law contractual entitlement to refer disputes to the Labour Court or the High Court, and separate from that, a claim under the Labour Relations Act for an alleged unfair dismissal. They can bring those disputes simultaneously, or they can bring them one after the other, but they certainly have both those rights. And also the court highlighted significantly that the claims are for different remedies. The claim before the High Court or the Labour Court would be for damages, whereas the claim before the CCMA is for compensation. And that the reliance upon the Labour Court on the James and Eskom decision was no authority for the employee not being able to bring two disputes, because in the James decision, very differently from this decision, the employee was inconsistent in what he presented to the CCMA with what he then presented to the Labour Court. So I think what's important from this judgment is when you look at costs and risks associated with dismissing employees, is to bear in mind that they don't only have recourse to refer a dispute to the CCMA for compensation, but also potentially, and depending upon the facts, to refer a dispute to the Labour Court or the High Court claiming damages for a breach of contract. And as we deal more and more with more senior people who have greater income potentially to pursue such disputes, we see an increase in employees referring both disputes to the CCMA and to the Labour Court, either concurrently or one after the other. If we can then move to the last slide, please. The last decision that I wanted to deal with is a decision of the Labour Appeal Court handed down in May of this year involving Samka and Shoprite Checkers. And this is a decision where the Labour Appeal Court was required to determine whether an employee can hold an employer liable in terms of Section 60 of the Employment Equity Act for discrimination perpetrated on the employee by a customer of the employer. Very briefly, the facts were that the employee was a cashier working at Shoprite Checkers. A white female customer came into the store. She had an exchange with the employee during which she allegedly called the employee stupid and used the K word. The employee was understandably aggrieved by that, and she referred a dispute to the CCMA. She alleged that the employer hadn't offered her the necessary assistance or understanding following the incident, and the commissioner found in the employee's favour, and that this amounted to unfair discrimination, and the employer hadn't discharged its obligations under Section 60 of the Employment Equity Act. The employer then appealed the decision to the Labour Court, and the Labour Court held that the decision of the CCMA was incorrect, and that Section 60 of the Employment Equity Act doesn't extend to cover instances where an employee is subjected to unfair discrimination by a third party, in this instance, the customer of the employer. The Labour Appeal Court was then required to consider the issue and look at the scope of Section 60, and it agreed with the finding of the Labour Court. It found expressly that the terms of Section 60 are limited to the conduct of an employee towards a fellow employee and doesn't extend to the conduct of third parties such as a customer. And the situation is, the court found, it makes good sense, it's common sense, because an employer doesn't have control, can't exercise control over a third party, it can only exercise control over its employees, and that the terminology and the wording of Section 60 is and it only extends and applies to employees as defined in the Employment Equity Act. What the court did also say, which is important, is that the employee was not without remedies against the customer. It could refer a dispute to the Equality Court, alternatively it could refer a delictual claim to the civil courts. So it wasn't without a remedy, despite the fact the employer wasn't held liable, because Section 60 is confined to the relationship between an employer and an employee and conduct by one employee in relation to a fellow employee. Thank you. If I can then hand over to my colleague, Masina.
Good morning, everyone. My topic is business transfers. Unfortunately, not too much has happened in the world of business transfers in the last year, except for the Constitutional Court confirming some legal principles and also confirming the difficulties in identifying when a transfer of a business occurs. Now, we know that in terms of Section 197 of the LRA, that in an instance when there is a transfer of the whole or part of any business, trade, undertaking or service from a transferring employer to an acquiring employer, there is an automatic transfer of contracts of employment. The new employer is automatically substituted in the place of the old employer in respect of all employment contracts which exist immediately prior to the transfer, unless obviously otherwise agreed. And it is this consequence of Section 197 that has drawn many an employer to litigation. So when does Section 197 actually apply? In the case of Nahawu versus University of Cape Town, the court found that in order for a transaction must exist. A transfer of an entity by one employer to another, the transferred entity must be the whole transferred as a going concern. All three requirements must be met in order for Section 197 to be applied. In the recently handed down Constitutional Court matter of Tassima Pty Limited versus Road Traffic Management Corporation, the Constitutional Court had to consider whether the transfer of the electronic national Thank you for changing the slides, Karushka. The Electronic National Traffic Information System, the eNaTIS as it is commonly known, to the RTMC constituted a transfer of a business. In 2001, TESIMA was awarded a tender by the Department of Transport to develop the eNaTIS system, which enabled the department to regulate the licensing of vehicles, driver's licenses, roadworthiness, etc. TESIMA, because of which develop, implement, support, and operate the system for a period of 5 years. In May 2007, the agreement was extended on a month-to-month basis and eventually extended for a further 5 years. Found that no proper procurement processes had been followed. Surprise, surprise. The department then attempted to terminate the agreement and have the system transferred back to the department, which led to lengthy litigation. TESIMA contended that the handover of the services back to the department fell under the ambit of Section 197. Consequently, it argued the department was required to accept automatic transfer of its employees. The Labour Court and the Labour Appeal Court directed accordingly. We know from previous case authority like Aviation Union and Mvula quality protection cases that although the definition of business in Section 1971 includes a service, what is capable of being transferred is the business that supplies the service and not the service itself. In light of this, let's look at the TESIMA judgment in a little bit more detail. The Constitutional Court determined that the legal basis for the transfer was critical to the determination of whether there was a transfer of a business as a going concern and hence applicability of Section 197. Karushka, if I can ask you to turn back to slide number 1. These are the elements that the court looked at and defined, both the majority judgments as well as the minority judgments. In determining whether there was business, the court considered that whilst the definition is broad, it adopted the concept of an economic entity, which we know now is defined as an ongoing grouping of persons and assets, facilitate the exercise of an economic activity which pursues a specific objective. The court found that the components of eNaTIS, the operation, maintenance, and management that were handed over by TESIMA constituted TESIMA's sole business and therefore constituted a business for the purpose of Section 197. Turning to the second issue of transfer, in determining whether a transfer had taken place, the court confirmed the position of Mvula and Aviation Union by finding that where services are involved, what must be transferred is the business that provides the service, that is the economic entity, and that mere termination of a service contract without something more cannot or will constitute a transfer in terms of the entity receiving the business was actually irrelevant. The only qualification is that the receiving entity must be capable of being an employer. And this was in response to the department or RTMC's contention that it was a regulator and therefore could not accept transfer of a service. The court rejected that argument. A transfer, the court said, entailed the movement of a business from one party to another and could take many forms. The old adage of substance over form came to play here and was found to be relevant, and the court found that there was a transfer, not a mere delivery of a product as contended by RTMC. There was no difference in the business before and after the transfer.
Sorry to interrupt. Can we just ask you just to switch off your video?
Yes, certainly I can do that. Is there
just a connection challenge? Thanks.
Connection. Apologies for that. Is that a bit better, I hope?
Thank you.
Turning to the issue of going concern, the court's primary consideration was the nature of the business. On the evidence before the court, the sole business of TESIMA had been the operation, management, and maintenance of eNaTIS. The court found that RTMC had run the entire undertaking which had previously been performed by TESIMA, thus having transferred as a going concern. In conclusion, the court found that 197 was applicable. There was a transfer been met. I want to deal a little bit with the minority judgment because that just shows how difficult it is to establish whether 197 applies or not. This is what minority judgment, it said in terms of the turnkey agreement, Tassima would hand over to the department the product, i.e. eNatus, not in fact a service. The department provided workspace for Tassima. The department owned the assets that Tassima used. Tassima employed its own workforce to develop the system. Tassima employed and remunerated employees to conduct its business. Its business comprised of designing and developing information systems. eNatus and its operation was not Tassima's business. There was no transfer of assets, employees, and supply of services. So on the same set of facts, the minority judgment found that RTMC had not acquired Tassima's business and there was no transfer of a business as a going concern. So what we get out of this is, firstly, the position of our courts is that where there is a special purpose vehicle whose main purpose is to provide a service which is taken over by the receiver of that service, Section 197 will most likely apply. However, there is no one-size-fits-all approach that can be applied. The determination of whether there has been a transfer must be carefully considered on a case-by-case basis. I'm hoping I have a couple of minutes more. I'd like to discuss another matter of MTN versus Pillay and others. The Labour Appeal Court in this case had to deal with the issue of whether prescription applied in relation to a claim for remuneration pursuant to a transfer of a business. The employees, so MTN took over the business previously owned by Interaction Call Centre. MTN denied that the takeover of Interaction Call Centre constituted a transfer of a business as a going concern and refused to recognise those employees as its employees. The employees applied to the Labour Court for an order declaring the transaction to be a transfer in terms of 197 and to be declared employees of MTN, I beg your pardon, with no loss of service or remuneration. MTN raised prescription as one of the defences in the Labour Court, contending that the claims for remuneration from 2010 onwards had prescribed as more than 3 years had elapsed since the remuneration became due in terms of the contracts of employment. The Labour Court declared that the transaction fell within the ambit of Section 197 and therefore constituted a transfer of a business as a going concern. The matter went to the LAC, taken by MTN. The LAC confirmed that contracts of employment continue uninterrupted and there is no need for employees to tender services. One of the other issues raised by MTN, both at the Labour Court and the Labour Appeal Court, is that there was no tender of services by the employees, and for that reason there was no 197 transfer. The Labour Appeal Court went further to confirm that the new employer steps into the transferor's shoes, and after the transfer is effected, simply employs the transferred employees as if they had always been on its payroll. The new employer therefore has a duty to pay the employees their wages as and when they fell due in terms of their respective contracts of employment. Accordingly, it found it was not required of the employees to tender their services because the employment continued uninterrupted. Lastly, the Labour Appeal Court held that the order of the Labour Court confirming that MTN was the employer effectively interrupted the running of prescription in respect of their claims for remuneration. The upshot of this decision is, firstly, an employee does not need to prove that services have been tendered in a claim for the payment of salaries unless the employer alleges that the service of the employee had not been provided. Secondly, a debt in terms of the Prescription Act is not deemed to be due until the creditor has knowledge of the identity of the debtor. Insofar as the employee is only established in law that MTN was indeed the employer by the declaratory order granted by the Labour Court on 21 April 2015, the debt only then became due. The prescription defence accordingly failed. And that's my story.
Thanks very much, Tina and Gillian. It's quite interesting to hear you talk, Gillian, about some of the difficulties experienced in Tennyson. And I was just thinking about all the various documents and annexures that can form part of very complicated contracts, and there's always a difficulty for both clients and drafters and attorneys whether to go a simple contract way and try to be quite general or to try to cover everything through detailed, laborious annexures. So I'd be interested to hear your views on that.
Thank you, Avinash. Yes, as you say, I mean, generally with executive contracts, there can be extensive contracts of employment with various annexures and cross-references. And I think that's one of the issues that the court needed to consider in the Tennyson decision, is looking at various permutations of terms and conditions over the years and how to reconcile those as changes are made. And it can often be problematic for an employer where you have various documents reflecting terms and conditions, and making sure when you make changes that those then supersede and replace earlier documents. And I think what's critical, though, as I said earlier when I was dealing with the decision, is just ensuring that as an employer you build in flexibility. And I think that's becoming more and more important, as we saw now with COVID-19, the need to have flexibility in your contracts and to have provisions like force majeure, that you've got a situation where if you're not able to allow the employee to tender their services, that the contract adequately deals with that. And we see that similarly in individual labour law when it comes to disciplining employees, that you build in flexibility and you don't over-regulate yourselves in terms of your own policies, because it's not the legislation that may trip you up and the Labour Relations Act and the policies in terms of that, but rather your own internal policies and procedures that may then trip you up. So it is, I think, critical to ensure that you get appropriate advice and you build in that flexibility into your contracts and your employee manuals and policies.
Thanks very much. And it's also going to be interesting, I think, to see what happens when we think about cases like Archer, and we hear you describe cases like Samka. What's going to happen to the entire labour litigation space now, also again affected by COVID, the impact on the market, the labour market, the ability of parties to litigate, the available funds that employees might have, because in Archer's case, we're talking about possibly double referrals in a sense to different fora that might be permitted, and that all of and likewise in Samka, where you deal with a customer of the store, and the court, blithely can say, well, if you don't like what the person says, you can sue the person directly rather than in the vicarious sense. But again, it's going to be very interesting to see what happens with the caseload. We heard Jose talk earlier about funding being cut, caseload overloads now, and backlogs as well. So those are all discussions for another day. I want to thank those presenters. Our next presentation focuses specifically on the topical issue of workplace health and safety, COIDA, and COVID-19. Michael Yates is a director in our employment practice. He has extensive experience in the field of health and safety, employee relations, and corporate immigration law, both from a litigation perspective and training and development. Michael works in various industries, including mining, metals, engineering, retail, financial services. Asma Kachalia completed her articles and worked as an associate in a small firm before joining CDH as an associate in 2020. Asma specializes in all aspects of general labour law. Michael, over to you.
Great, Avinash, thank you so much for the introduction. And yes, I hope that everybody online has had the opportunity to see the President's announcement last night, where it seems like we're moving to alert level 1 at midnight on Sunday evening. But I think it is safe to say that we are still expected to comply with the certain restrictions under alert level 1, with compliance with an employer's obligations to prevent the transmission of COVID-19 in the workplace. I do feel, however, that moving over into level 1 may have a bit of a negative effect, where employers and employees may relax a little bit. Level 1 certainly feels a lot less serious than level 5, for instance. And I think this is where employers should really take caution of not to lose sight or take your eye off the ball in terms of your obligations in terms of occupational health and safety. We saw some interesting case law come out during the course of the lockdown, particularly when relating to health and safety in the workplace. One of the judgments that we saw is the matter of AMCU versus the Minister of Mineral Resources, where the judge effectively interdicted or ordered the Chief Inspector of Mines to prepare and implement a code of practice to mitigate the effect of the outbreak of COVID in mines specifically. But I don't really want to speak about that judgment, but I do want to speak about some of the important things that Judge van Niekerk had said in relation to COVID and occupational health and safety, because there was an argument raised during this judgment that COVID-19 is not necessarily seen as an occupational disease. What Judge van Niekerk said is that COVID-19 is a public health issue as well as an occupational health issue. He said that these two concepts were not discrete categories, and that an occupational response was required in relation to COVID-19. Importantly, what the judge had said is that there was a fundamental overlap between public health and occupational health, and stated that occupational health deals with a subset of the population and is concerned with the health of not only the worker and their geographical workplace, but also the persons or populations affected directly or indirectly by operations in a particular work site or access a particular industry. Now, this kind of judgment has a far-reaching implication, as we've seen various flu strains come through the world. We're all reminded of the swine flu, the aviation flu, now COVID, and we don't know exactly what mutations we may see coming out in future. We are certainly warned by the experts and by the authorities of the dreaded second wave, which may result in us reverting back to a more restrictive level 2, level 3, level 4 kind of lockdown in order to gauge the medical response abilities of our government. The point being, though, is that during the course of the lockdown, the importance of health and safety in the workplace was really thrust into the limelight, and this has left a lot of employers who are not necessarily health and safety focused to rush towards their OSH acts and to dust it off to see where their obligations start and end with COVID-19. Essentially, a review of the literature on health and safety identifies certain critical components of an effective safety, health and environment, or a SHE management system framework. And these would typically consist of elements such as leadership, commitment, managing human factors, effective process and management controls being in place, resource allocation, effective SHE design and communication, all form key components of an effective health and safety management system. We've heard earlier about Riola speak about the CDH tool, which deals with training on the employer's obligations in terms of COVID, and this is a very effective tool which employers can use with an auditable trail to make sure that they are COVID-19 compliant. Now, during the course of July 2020, the Department of Employment and Labour did a survey study, and they found, shockingly, however, that only 47% of employers in the public sector were compliant with their obligations in relation to COVID-19, whereas 57% of employers were compliant in the private sector. As of the middle of July, the Department of Employment and Labour had issued out over 2,500 notices and almost 400 prohibition notices to employers, and I surely hope that those figures in terms of compliance have improved and will not trail down as we move over into level 1. If we can just go on to the next slide, please. Now, in terms of an employer's obligations, and I don't mean to rehash in terms of the limited time that I've got available exactly what needs to be contained in an employer's workplace plan dealing with COVID-19, but it'll be sufficient for me to state that that an employer has to make sure that whatever preventative measures it puts in place are reasonably practicable, and that they exercise the control required in order to prevent the transmission of COVID-19 in the workplace. Now, this will include, as I've mentioned before, having your workplace plan in place, effective communication of that workplace plan to your employees. For instance, inform employees who are sick not to come to work, or to take leave, and also to enforce social distancing and hygiene protocols. But the big question that one has to ask is what rights do employees have when they feel that their employer is not doing enough or is not complying with the prescripts of the National Disaster Act or the directives they're under, or if they just feel that their particular circumstances are subjecting themselves to a real threat of contracting COVID-19 in the workplace, despite an employer having a workplace plan in place. Now, we take guidance from the provisions of the Mine Health and Safety Act, where there is a particular provision under Section 23 that an employee has a right to leave any workplace where there is a reasonable justification, where the employee believes that being in that workplace poses a significant and serious risk to their health or safety. If you can just go over to the next slide. And we can skip this one as well. Okay. In the matter of the National Union of Mine Workers and Schrober Slate, which is a relatively old judgment because it emanates from 2007, the court held that an employee who exercises this right to withdraw their labour from an unsafe workplace must rely on objective information, and that the employee left the workplace because of that threat. It's important to state that the belief that the situation or the workplace was unsafe doesn't need to be correct. The employee doesn't have to be factually correct, but their belief must be reasonable and based on objective information that was available to them at the time. Now, strangely, the Occupational Health and Safety Act, which regulates all other workplaces other than mines, doesn't have a comparative section in it, such as in the MS, in terms of the Mine Health and Safety Act. However, some occupations present a particularly increased risk of exposure of infection. The contraction of COVID-19 does not necessarily attract the rebuttable presumption in all workplaces that it was contracted at the workplace. And I will leave that aspect of occupationally acquired COVID-19 to ISMA to speak about, because she will be speaking about COIDA claims. But it is sufficient for me to mention that the onus to prove that an employee contracted COVID-19 at the workplace falls on the employee to prove that he or she attracted it by virtue of the fact of his or her activities, working activities. However, in June 2000, on the 4th of June, we saw the Consolidated Health and Safety Directive being issued out by government, which sort of artificially implemented or imported the same kind of relief to employees that we saw under the Mine Health and Safety Act into the Occupational Health and Safety, by stating that if an employee has a reasonable fear of contracting COVID-19 in the workplace as a result of the fact that that workplace represents an imminent or serious risk to his or her health and safety, the employee may refuse to work. Although the Schroeder-Slate case dealt specifically with the provisions of the Mine Health and Safety Act, we would argue that the same kind of considerations would apply in the Occupational Health and Safety consideration and the directive, that when an employee exercises that right to not report for work or to withhold their labour because of this imminent fear, that must be based on objective information, and that the decision by the employee must be reasonable. Can we just go to the next slide, please? Okay, sorry. Now, what must an employer do when they do realize that an employee is exercising this right to withhold their rights to work due to this fear of contracting COVID-19 in the workplace? Well, firstly, the employer must consult with their compliance officer and any applicable health and safety committee to resolve the issues that have been raised by the employee. This will typically involve an examination of the reasonable justifications which the employee has put forward as to why they are withholding their labour and the fears that they have. An employee may justifiably withhold their labour if they feel that the preventative measures implemented by the employer is either not sufficient to protect them or doesn't comply with what is reasonably practicable under the circumstances. Now, I don't want to go into a whole debate about what constitutes reasonable practicable measures by an employer, but it's safe to state that reasonable practicable reasons don't necessarily completely eliminate risk of contracting COVID-19, but the duty at least remains on the employer to ensure that it implements measures that would minimize the risk so far as reasonably practicable. This will then mean that there would have to be a careful balancing act and an evaluation of the employee's reasonable justification for withholding his or her labour versus the measures implemented by the employer to prevent the transmission of COVID-19. And as you can imagine, this can sometimes become the topic of some hot debate between employers, employees, trade unions, and so on. I think we're going to see a lot more of this kind of litigation creep through, whether it's going to manifest itself in terms of the collective bargaining space, or whether it's going to see itself play out in the individual labour law space of the CCMA. Still remains to be seen. We haven't had the luxury of time to see these kind of disputes ventilate themselves through our courts, but it is safe to say that we are going to be dealing with COVID-19 well into the future, and any other reiterations of COVID-19 or whatever other flu strains may come along. So this is for certain our new normal. I think on that note, I would like to hand over to Isma, who will be speaking about the COVID COIDA aspect of contracting occupationally acquired COVID-19. Thank you very much.
Good morning, everyone. Thanks, Michael. Yes, so I'll be talking about the compensation for workplace acquired COVID-19, and more particularly the directive that was issued in June of this year by the Minister, which clarifies the position of the compensation fund with regard to claims for workplace contracted COVID-19. Now, the directive deals mainly with 4 aspects, and that is the diagnosis, the level of impairment, the benefits, and then the actual reporting when you submit claims. In terms of the diagnosis, workplace acquired COVID-19 depends mainly on exposure to a known source of COVID in the workplace. It can also be from official trips that you would take on work assignments, specifically if you're taking international trips to maybe high-risk countries, the countries that we deem high risk. But after that, there should then definitely be a reliable diagnosis. And this diagnosis should be done using the WHO guidelines, which we usually consider the normal swab test where specimen is collected. But it can also be a test that is approved, or something that the Department of Health would approve in this case as well. It's also important to look at the chronological sequence between exposure at the workplace and then the ultimate development of symptoms. So we know that in terms of Section 45 of COIDA, that all claims have to be considered by the compensation fund, and in order for them to determine liability, and they need to peruse all submitted information in order to make an objective decision on whether they will claim liability. But what's specific to COIDA is that the compensation fund will look at the inherent risks, and what they've done in the directive is they have categorized the risk of occupations from very high risk down to low risk. Now, our very high risk occupations would obviously be our heroes, our frontliners, our doctors and nurses, and our paramedics. We then would move on to something a bit of a high risk, so not very high, and that would still be our health workers, but more our health work support staff, delivery vehicles. Our medium risk occupations would then include occupations where you would have interaction with the general public, but those with known diagnosis of COVID-19. So usually people who work in areas where they interact with international travelers, specifically those who come from high-risk countries. We then have low-risk occupations, which then would be your normal office jobs, where you wouldn't ordinarily interact with the general public or any known case of COVID-19. What's important and what's sad is that about 2 months ago, the Health Ministry said that about 13,000 South African health workers were infected by COVID-19, simply based on the fact that they just work in those conditions, and that, I mean, hundreds of them are being killed, and it's sad that we lose our frontliners, but that's the reality of the situation. It's important to note also, after having discussed the occupations and their risk, is that these are just guidelines, and it doesn't matter what occupation you're in, you will still be able to submit a claim if you've contracted the virus at work, and you'd be entitled as an employee to do that. We can now move on to levels of impairment. Now, with COVID being a fairly new virus, it's been difficult to sort of determine what kind of damage COVID does in the long run. And so what this directive specifically says is that permanent impairment must be determined 3 months after diagnosis, but also when maximum medical improvement has been reached. Impairment is determined from the complications that you would ordinarily experience as a result of COVID. So where these medical complications come up, there would need to be further tests, specifically because it's a novel virus. And there have been reports sort of later on down the line. I'm not a medical expert, but there have been reports that the other complications have come up, and doctors have sometimes attributed it to COVID-19. What's important is that you have to have reached maximum medical improvement before you would then determine whether any abnormalities sort of exists. With regard to temporary total disablement, the fund will pay out for the duration of that disablement, but obviously not over the amount of 30 days. And also, because it's such a novel virus, additional tests will need to be done in order to determine whether this temporary disablement is actually a result of COVID-19. The fund does not provide compensation for unconfirmed cases, which are still being investigated. And usually for cases of self-quarantine or self-isolation, the employee would have to follow the TERS directive, or, as Michael mentioned, the Consolidated COVID Directive on Health and Safety, whichever is applicable in the specific case. And sadly, obviously, we've had a lot of cases of death. And if you die as a result of COVID, reasonable burial expenses will be paid. And then obviously widows and widowers and dependents will be paid out their pensions, whatever is applicable. Now, in terms of reporting, documentations and forms, the usual documentation and forms would need to be submitted to the fund. But what's also interesting about COVID is that there has to be a lot of medical reports. Again, based on the fact that COVID is so novel, they have to be, the compensation fund has to be sure, and they take into consideration detailed medical reports before they accept liability. So within the directive, they have an employer's questionnaire, which you must then fill out, also specific to COVID. So ultimately, when an employer becomes aware that an employee has been diagnosed with COVID-19 or is being suspected of having contracted COVID-19 as a result of work exposure, it would, as the employer would do well to obviously consider the COVID directive, but also remember that it has to be read with COIDA. After the reports are submitted, the commissioner will then process these claims. Now, what's interesting is that I've tried to do some research on the amount of claims that have been submitted so far. I mean, we have to remember that this only really spiked in March, and that's just not many months before. But in August 2020, government actually released a statement where they stated that 2,036 claims have already been submitted directly to the compensation fund. The compensation fund actually accepted liability of 1,229, which represents about 60.4%, which is quite a large amount. They've repudiated about 193, which is about 9.5%, and we are still awaiting about 614. So this was in August. So obviously that figure could change, and that represents about 30.1%. But also the commissioner pointed out that in cases where the claims were repudiated, when they've received better information, these claims could still be approved, and the compensation fund could at that stage also accept liability, which is quite interesting. I think with this virus and how little we know about it, that's probably something that they should consider. As Michael pointed out before, in the meantime, there's appeals by the department, and I mean, it should be something that all employees take into consideration, is that we still need to care about the lives of our workforce, and we need to take the necessary precautions in order to ensure their safety. And that can be done using, the basic guidelines that Michael has pointed out: washing of hands where possible, keep safe distances, wear protective gear. And I think that's the most important part regarding health and safety in COVID. Thank you.
Thank you very much, Michael and Asma. Just a couple of questions. Your presentations elicited a lot of thinking, I think, in terms of the new normal. I mean, we heard the president speak last night, and what is the new normal really going to mean under level 1? You can imagine the tension between pushing for people to return to work en masse versus a staggered approach where working from home is still going to be encouraged where this is possible. I think about the team building challenges where eager Viva managers would like to have their entire teams in place, and now see level 1 as being an invitation to bring the entire workforce back en masse, possibly wearing masks. So I'm grappling with that type of issue of how much flexibility is going to be tolerated. What about instances where there are unreasonable refusals to come back to work? What's going to happen with workplace travel? Are those business trips to New York or London really necessary in the context of COVID? And how does that gel with level 1 return? And then perhaps finally to ask you, perhaps a thought, how does the culture of an organization play a role in how this is going to play out, whatever the legal regime is? Thank you.
Yes, no, thank you very much. I think we've definitely seen a shift of a new dynamic in the workplace where employers are making use of the technological means available to them. Such as this, we have webinars over video conferencing facilities and so on, but this is not necessarily available to all employers or industries. I think where employers do make use of the work at home kind of model or technological means, we will be carrying on much in the same fashion as what we are now. But from a cultural change, I think that there will be a lot more emphasis on hygiene, of course, a lot more emphasis on an employer's obligation or duties towards employees, And I think in terms of the MCU and versus Minister of Mineral Resources judgment, we are going to be seeing a lot more of these kind of arguments come through, not necessarily in terms of COVID-19 specifically, but in terms of other diseases in the workplace as well, where it has now been made clear that there is no bright line between occupational health and public health, where a serious public health concern may infiltrate itself into the workplace or vice versa and influence the environment. So there'll definitely be a lot more emphasis on health and safety, protocols being in place, and more importantly, that those systems are effective. And I wouldn't be surprised if the trade unions make use of this this opportunity to hold employers accountable to their obligations in this respect.
Thanks, Michael. Asma, from your side, is there anything you'd like to add?
Yeah, no, I agree with Michael in terms of the culture. I also agree with him in terms of the trade unions possibly using this as something to hold the employers accountable to. And definitely, yes, there'll be a whole new normal when it comes to work and working from home in general. Yeah, but Michael's hit the nail on the head in answering that question. Thanks, Avinash.
Thank you very much. We've continued to receive some interesting questions in this area, but we'd like to move on. We'll address these via the chat feature and in the follow-up material. The one relates to what the impact is going to be on the other type of diseases like tuberculosis and others that might have been underemphasized in the past. And of course, we've just seen a recent amendment to COIDA, which is out still for comment, and the introduction of more measures for rehabilitation. We see PTSD being covered, so it's going to be interesting to see what the country's pulse is going to be like in respect of major healthcare challenges going forward, and ones that we may have neglected in the past. We're going to shift our program slightly and move to the presentation focusing on strikes. It's always a great pleasure to introduce Professor Hugo Pina, who is a director in our employment practice. He has vast experience in employment law and litigation and dispute resolution matters, and represents a number of major corporations in South Africa. Hugo has also published in academic journals on various employment law topics and has done a number of television and radio interviews. He's joined by Sean Jameson, who joined CDH as a candidate attorney in 2015. He was promoted this year to senior associate and has expertise in all aspects of labor law. And finally, the team includes Jaden Kramer, who joined CDH as a candidate attorney in 2018 and was promoted to an
Am I ready to proceed?
Yes, thank you, Hugo.
Thank you. Welcome, everybody, again. Well, may I start off with the good news for all HR and IR practitioners, in the sense that the strike season has now been extended and now includes the period 1 to 9 January every year and 21 December to 31 December every year. Unlike in the past where it started off for a short period of April to July. So what I intend to discuss is that I think in future, in terms of strikes, and I'm talking about protected strikes within the violent sphere that it operates, is that you may in fact need 3 interdicts to normalize the situation. That is the one point I'm going to raise, and then the last one is that given the principle of common purpose, or the doctrine of common purpose, how you should introduce that in your planning after the strike. So when we talk about strikes, we know it's against the background of a high rate of unemployment. We know that there are unions still going on strike action, or calling their members on to strike in respect of a demand for higher wages, That's despite the high rate of unemployment and the economic harm suffered by parties and employers. So you still have that. On the other hand, you have unions that said, well, let's sacrifice the agreed wage increases this year, and what we will do is we will not demand a wage increase provided we have some sort of quid pro quo, i.e. no retrenchments. And that's certainly the way to go. The sad reality is that we know that union memberships and unions, it's all about a business, and a business means we need as many members as possible, and we have a lot of unregistered trade unions who will endeavour to expose those trade unions who entered into agreements with companies as sellouts and say, well, we promise you something different, and then they take over the employees' membership, and ultimately you will have further strikes. The other reality in our context is, of course, still the problem that we have very or no support from the SAPS when we have a strike action on our doorsteps. We don't need to debate that. And of course, the other concerning point is during strikes that employers don't necessarily settle because of the normal economic pressures borne about by strike action, but they settle because of the violence. And I think that is a difficulty and challenge we face as employers. So when we look at a typical protected strike, and I just want to take you now to the potential 3 interdicts that you will have to deal with. And we now know that it's a protected strike, picketing rules are in place, and you receive your notice of a strike. Of course, the appropriate thing we think one should do in order to harmonize the power play later is for employers to then issue a lockout notice. And you'll see it comes in handy at the end of the process when the union wants to suspend the strike and you want finality, and then you invoke the lockout, or the lockout should be in place. So now you can return to work once you've accepted the employer's counter proposal, or once you've waived or abandoned your demands. So the starting point, of course, you receive the strike notice, picketing rules are in place, there's immediate breach of picketing rules, and the first interdict we know you bring is to enforce picketing rules, to say to the court, these are the breaches, you show to court, and the court then issues an order that says that the employees must comply with the picketing rules. Of course, we know from our experience that does not necessarily help, and you will then have a further spate of violence and sometimes increased violence. And then you bring your second application, and you will know that CDH did the first one of its kind in South Africa, and we've done this now on a regular basis, where you approach the court and now interdict the picketing. So the strike may continue, but no picketing, and of course that disarms the union. We know that strike action and picketing will often be taken into the areas where people live, and that happens in any event, and that is the difficulty we face in South Africa. But the point is, so you have a second interdict where you now suspend the picketing. So employees will continue to strike, and of course then you will have, or potentially have, different forms of violence. And it's at this stage where we often find that the unions will then approach us and say, now we can talk settlement because the balance of power has shifted. Be that as it may, we often find that there's then further continuation of violence, and it's in that environment where I think there's in future to come a possible further interdict. And this is now where you will bring an interdict to stop the strike. In other words, to force the employees to return to work because the strike is marked with violence and it's not conducive to collective bargaining. And that case law will certainly be developed within the next year or two. So that's just by way of background in terms of the 3 strike scenario. If we can move to the next slide, please. What we then need to discuss, what often happens is after the strike. Now you've had the strike, you've identified the perpetrators, and now you want to discipline your employees. Let me just see if I need to switch off the mic or the video. So the scenario now is that the employees are back at work. You suspended the main perpetrators. How do you go about in minimizing your risk in getting rid of the main culprits? Now, there are three principles that will come into play. The one is the one about derivative misconduct, and you'll recall we discussed that in the past, where you issue letters ideally prior to the commencement of the strike, where you invite employees, in fact, you may even instruct them to disclose misconduct of fellow employees. Failing to do so constitutes misconduct in itself, provided in terms of the Concord case and Dunlop that you would provide some sort of security, i.e. non-disclosure of identity, having evidence let in camera in terms of the deal flow principles. So derivative misconduct, one concept that you need to deal with. The second thing, second risk and concept is this one of inconsistency. Inevitably in a strike where you've had, let's say 1,000 or more employees embarking on a strike, and you've identified 200 or 100 culprits, that you will miss out on some. And then you often have the scenario that you get to the CCMA or otherwise where they say, you've acted inconsistently, you've had 10 managers and one of the managers didn't dismiss people performing or committing similar misconduct. Now, again, there's this concept or perception that when you deal with inconsistency, that constitutes an absolute defense. Of course, it's not correct. A mistake by a chairperson does not allow the majority of people to profit from that. There must be some sort of malicious intent. So the mere fact that there was some form of inconsistency is not a defense, but you need to be wary of that. What we've done in the past is we invite people to say, show us the inconsistencies, and then we will proceed to dismiss those employees as well. And that has caused unions to then not pursue that action. And we've done that effectively in a few cases. The next principle that you'll deal with is this one of common purpose. It's a doctrine well entrenched in our law, in criminal law, but also in terms of labor law. And what has happened in this Marley Pipes case is to show how far the court has pushed this principle of common purpose, where an employee who was not part of the attack on a particular employee of the company, I think the HR person, who was not part of the attack itself, but after the attack associated him with the conduct of the strikers when they returned, and that there was a big song and dance, and he then associated himself with that conduct. And the court held that that constitutes part of common falls within the ambit of common purpose, and the employer was entitled to dismiss him. It would be no surprise to you that that was also a case done by one of the CDH teams and successfully defended the company. So in short then, how do we deal with this concept and the principles is, of course, after the strike, how do you formalize your charge sheets? In particular, it's not just the conduct itself, but also the association with that sort of conduct. So look at how we formulate that. The last point really is about your disciplinary code and procedure that is simply too onerous to deal with a typical strike misconduct scenario. And our suggestion is that you start amending those and make provision for a simplified approach where you will not have, as we currently have, 100 or 200 hearings, but where you would have one joint session where people make presentations, put before an independent person with some form of evidence, and you get the hearing concluded within a day or two, as opposed to the current challenges we face. So that is in short how we see strikes, the three interdicts possibly, but the planning afterwards in order to get rid of perpetrators equally important in order to limit your exposure. Of course, as you would know, that we have strike packs, etc. available to assist you during strikes and otherwise, ultimatums included, so that when you do the ultimatums in unprotected strikes, that you comply with the Steve Spa in those cases. So I'm now going to hand you over to Sean Jameson, who's not only famous for the whiskey that he manufactures, but he can in fact do a strike interdict within 2 hours, blindfolded, I think, by now. Sean, thank you. Over to you.
Thanks very much for that introduction, Hugo, and good morning to everyone. I trust you're enjoying the presentation so far. I'm going to be dealing just very briefly with two very interesting judgments that came out recently. The first judgment is, as you'll see from the slides, Max Steel Service Centres versus NUMSA. Now, this was probably, when it comes to strike law, the most interesting judgment that came out during the lockdown period. What happened here, the issue in dispute was the old question that various employers have had to consider during lockdown, and that is whether we need to implement salary reductions in order to sustain our operations. Now, a lot of employers have had to consider this, and the tricky part was, how do we go about it? Can we implement it unilaterally to avoid retrenchments and the like? Now, briefly in this case, the facts were as follows. We know that in March, we went into a hard lockdown. Various industries had to cease their operations completely. With Max Steel, despite being closed completely for March and April, they were on a full shutdown. They did the honourable thing, and they managed to pay their employees who were not tendering services because of the lockdown, their full salaries. And this was in accordance with what President Ramaphosa said when he announced the lockdowns, that employers must, to the best of their abilities, look after their employees. And obviously, when it came to May, level 4 was announced, and Max Steel was allowed to start working again at 50%. So what we had here is half the workforce is working and half is still sitting at home not tendering services. What Max Steel said is, even with the 50%, we're going to continue to pay everyone 100% of their salaries because we don't want to differentiate. Again, quite an honourable thing to do in such tough circumstances. Now, initially, Max Steel didn't anticipate that lockdown would go on for so long, and hence it decided to pay the full salaries, but obviously reserves ran low. And what they then communicated was that because they didn't anticipate the extent of the lockdown, that they would be implementing, amongst other things, a 20% salary cut for all employees. Now, many employers had to implement salary cuts, but the trick is, how did Max Steel go about doing it? They effectively sent a letter to their employees and said, we are implementing the salary cut unilaterally in order to sustain operations. And NUMSA, despite Max Steel's honourable conduct in paying salaries for the previous 3 months, issued a notice to strike alleging a unilateral change to terms and conditions of employment. Now, Max Steel approached the Labour Court to try and interdict the strike, and the judge had to determine, was this a unilateral change to terms and conditions of employment? Max Steel implemented it without consent. Now, the employer's argument really was, it's COVID-19, it's lockdown, these are extraordinary circumstances, we've applied for TERS, in all likelihood, they're going to get their full salaries in due course. And interestingly, the judge, I think it was paragraph 82, stated that it was commendable by Max Steel to try and treat all employees the same, those who are at home, those who were working, etc., trying not to differentiate, paying employees their full salaries. However, the judge held in law, there's a difference. Those who did not work were not entitled to their salaries, despite the employer's good conduct, and those who did were entitled to their full contractual salaries. So despite the employer's good intentions here, it was still ruled to be a unilateral change to terms and conditions, because the employees who had come back during level 4, they were tendering their full services, and contractually, they're entitled to 100% of their salaries unless they agree to a reduction. So the court held this was a unilateral change. So in conclusion on this case, really what the judge here has said, despite your honourable intentions, the law is the law. These were indeed exceptional circumstances. But really what the conclusion here is, employers must still act with caution before taking decisions that may be intended to change terms and conditions of employment, because legally how a judge may apply it would be an application of law that would probably be irrespective of the good intentions of the employer and the extraordinary circumstances as we've seen with COVID. It's not to say that the judge was not critical of the parties in this matter. In fact, the judge stated that this could have been resolved through common sense, but that common sense is not a flower that grows in every garden. So that's an interesting case that surfaced with unilateral changes to terms and conditions. If we can move to the next slide, the Plastic Converters Association again versus NUMSA. Now, this case, also a recent case, dealt with the test for holding a trade union in contempt of court after obtaining an interdict. Hugo previously mentioned that a common problem in South African strikes is the violence that plagues those strikes. And this is what we saw in this case. So briefly, there was a strike from NUMSA and its members over wage increases. And as I've already said, the strike was marred by violence. Non-striking employees were almost beaten to death. There were petrol bombs going, things we see in the news often, unfortunately. Now, the employer approached the Labour Court on an urgent basis to interdict the unlawful conduct, not the strike, but the unlawful conduct that was taking place, and they were successful. So the employees and the union were interdicted from perpetrating further acts of unlawful conduct. However, again, as we often see in South African strike law, the violence simply continued after the court interdict, and that necessitated the employer to approach the Labour Court again to institute contempt proceedings against NUMSA specifically. Now, the Labour Court had to consider various issues here. It was, in fact, a 58-page judgment. It was a very, very intense judgment. But the main issue that the Labour Court had to determine here was the liability of a trade union in contempt proceedings. And the court held that the liability of a trade union is strictly limited to what the Labour Court orders the trade union itself to do or not to do. And importantly, it held that a trade union can't be held vicariously liable for contempt by union members. It can only be held vicariously liable if the contempt is committed by the trade union itself through its union officials. So that's very important. One can't approach the Labour Court to hold NUMSA in contempt of court because its members are breaching the court order. One would have to prove that the trade union through its union officials are breaching the court order. Interestingly, the court addressed the issue of whether NUMSA was in contempt, and the court held that a court directive to take all reasonable steps to persuade members not to commit acts of violence. That was part of the court order, and that's where the employer wanted to seek contempt against the union. The court held that a direction to persuade members not to commit acts of violence, that is too vague to be held in contempt of court. What you need to do in your court orders is set out specific steps that an employer needs to take. And in that way, you can hold them in contempt of court. Where there were specific steps and where NUMSA had not complied or had partially complied, the judge held that the employer could still not prove that that non-compliance was willful. Now that's critical. The judge reiterated the high threshold and reiterated the requirements for contempt. The first one is that there must be a court order. We had that. There must be service of that court order. We had that. Willful non-compliance. There was issues of that by NUMSA, but the biggest one was proving the willfulness of the non-compliance. So you have non-compliance, but you have to prove that NUMSA or the union or the party you're trying to hold in contempt, there was a willfulness about that non-compliance. And that was the biggest issue. And you need to prove all those elements beyond reasonable doubt. It's a criminal test. So unfortunately, the union was not able to hold NUMSA in contempt of court, but it does help us as employers in how to prepare going forward. So where we do have a violent strike and we get a court interdict against the unlawful conduct, we need to, as employers, start preparing beforehand how we're going to approach potential contempt proceedings. One is we must look at the individual members' themselves, because we know the union can't be vicariously liable for union members. So we need to have our preparations ready to identify the individual perpetrators themselves and prove willful non-compliance and hold them in contempt of court. Where we want to hold a trade union in contempt of court, one, we've got to set out very, very specific steps that a union needs to take in terms of a court order so that we can prove that it's not vague and that they have failed to comply with those steps. Secondly, we need to, in our preparations, focus on identifying trade union officials who are breaching the court order, because that, the court said in this matter, you can hold a union vicariously liable for. But the overriding issue in this case was, can you prove willful non-compliance? And that's the key we need, the lesson we need to take out of this case when we deal with violent strikes going forward and potential contempt proceedings. Those are the two cases I was looking to address you on. I'm now going to hand over to Jaden Kramer. He is an associate in our team, my team and Hugo Pinar's team, and he's going to be addressing a very, very interesting judgment that CDH was involved in, and it's so relevant because, as we've seen the EFF in the news recently. But let me not delve into the merits of that. I'll now hand over to Jaden Kramer. Thank you, everyone.
Thanks, Sean. So what I'm going to be talking about is the Culligan Lounge case. This is a case that it's not the most recent case. It's actually a 2018 judgment. But like Sean said, given what's played out in the political landscape and in the media recently, it's a very relevant case at the moment. And therefore, we decided to briefly touch on this before closing our portion of the strike presentation. So this case essentially concerned an urgent application to interdict striking employees of Culligan Lounge who had embarked on an unprotected strike, as well as interdict the EFF from interfering in the employment relationship. The EFF in this case had delivered what the court termed an inflammatory political manifesto, rather than genuine workplace grievances which would lead to a resolution. And the court in this case specifically considered the role of the EFF in the workplace, and simply put, the judge held that the EFF is not a trade union, but a political party, and that they have no business in the workplace and in workplace disputes, and that there's absolutely no room for politics in the employment relationship or in employment in general. So in amplification of this, and in a show of dissent for the EFF's involvement and conduct in this case, the court actually awarded costs against the EFF, which was very telling. Ultimately, the takeaway here, and like I said, this would be very brief, is the takeaway here is that while it might seem like there's a thin line between politics, the law, and the employment relationship, it should be remembered that the Constitution, the Labour Relations Act, and the various other pieces of employment legislation clearly distinguish and define the two as separate, and there's absolutely no room for politics in the employment relationship. Thank you. That concludes our strike portion of the presentation. I'll now hand back to Avinash, who will take us through the questions. Thank you.
Thanks very much, Hugo, Sean, and Jaden, for really interesting presentations, and I think also particularly invaluable to share some of the strike strategy linked to power plays and the techniques that are used by the practice in order to deal with some really key issues that crop up all the time. So one of the questions I'm going to pose to Hugo are the general circumstances under which employers can interdict picketing. I think that has struck a chord, Hugo, just the potential and that separation between the strike continuing on the one hand, but the interdicting of picketing. And then once you are through, if I could ask Sean to perhaps just delve a little bit deeper into some of the challenges from an evidentiary perspective in terms of actually proving willful non-compliance from a practical basis. What are the techniques that can possibly assist in that regard? Over to you.
Yeah, so I'll just start with Themba's part first, Avinash, and that is what do we need to show to the court, or how must we satisfy the court in order to obtain the second interdict, i.e. to now suspend the picketing. So you would now have your first court order, and as most employers would do nowadays with the benefit of electronic equipment and otherwise and videos, is that you will capture non-compliance. And the non-compliance would be by way of video, showing the video non-compliance, people outside the picketing area, stopping access to and from the company's premises. And you would also sometimes have affidavits or reports of affidavits of people being intimidated from coming to work. So it's a simple matter of putting that under affidavit before the court, show that there was non-compliance of the picketing rules and an abuse of that. And the approach is really, after you looked at Snyman's first judgment in the Diske matter, that if the employees don't exercise their right to picket in terms of the rules and peacefully, then they will forfeit that right. So you need to show an abuse almost of that right. But we've seen in the recent cases that we've brought, it's relatively simple to put that evidence before court. And the last one we did was about 2 or 3 weeks ago before Vanica. He simply looked at that and said, well, there's clearly non-compliance, and interdicted the picketing. Sean, you can go.
Thank you, Hugo. Thanks, Avinash. Avinash, I think your question is a relevant one. And there is evidentiary issues that employers are faced with when it comes to contempt proceedings. The starting point is that it's a criminal test. It is beyond reasonable doubt. And Hugo's mentioned in his answer some of the techniques we need to prove. What we found often works is when we know we are getting to a situation where we're going to bring contempt proceedings, employers should have a delegated task team on the ground who are focusing purely on identifying perpetrators of misconduct, getting the appropriate photographs, the appropriate video footage. And as Hugo mentioned, things like affidavits also go a long way to putting them on the back foot, to having to refute that evidence. The difficulty, Avinash, is when strikes are exceptionally violent, as they often are, it's often unsafe to be walking around with a video camera or a cell phone camera trying to identify people. So that's where you need to be practical in your solution. So we've had clients who have deployed drone technology. We've even had a client a few years ago with a really, really violent strike of hundreds of employees deploy a helicopter to obtain that footage. So not to say that you always need to go to those extents, but you need to be creative depending on the situation of the strike, not to place anyone's life or safety at risk, but to be creative as to how to identify. The other trick that is often used, and Judge Van Niekerk has confirmed, this constitutes contempt. When you're applying for your court orders, include a provision in that court order that the union or various respondents must file an affidavit demonstrating compliance with the terms of the court order by a certain date. 9 times out of 10, unfortunately, the unions will not comply with that. And Judge Van Niekerk has said your failure to demonstrate to this court, as per the initial court order, to file that affidavit or come and explain your compliance, that in itself constitutes contempt of court. So that's also another avenue you can look at strategically in trying to pass this test of proving willful non-compliance. Thank you, Avinash.
Thanks very much, Sean. We've got time for a couple more questions, though. The one I'm going to throw at Hugo relates to camera evidence and to reflect on that in a little bit more detail. And then Sean, if I can ask you, one of the questions we've received relates to how formal one needs to be in terms of disciplinary processes. It's perhaps a more broader question. Even, if it's clear in a disciplinary code that for this sanction it's a warning or a final warning, does an employer need to go through the motions of charging an employee with that, or can they simply issue that sanction with a very, very truncated process? Hugo, if you'd like to talk first.
Yeah, thank you, Avinash. So often after the strike, you would have employees coming forward and report certain incidents or you know that they're aware, but they're not prepared to testify at an open forum. And that is understandable also simply because this concept of urine impimpi, which we know create huge problems for those employees. But what we must not forget is that principle of leading evidence in camera, and the Dielkraal case sets out those procedures in quite detail. But it is quite simple in the sense that you will have different rooms where the witness would often sit in a different town as a starting point, and then the witness will sit with the commissioner at the separate venue. The rest of the people, including the representatives of both parties, would sit with the employees, etc., at the company premises or wherever. But the first point is separate venues, and you'll ensure that when the witness travels there, that the witness is not identified through his absence at work or otherwise. So we often take all the precautionary measures, and then a manager would go into the office and say, "Hi, you must go and testify." And of course, then everybody knows. So, you know, you need to take those precautionary measures. And then the next one is, of course, the voice distorter. You put in the voice distorter and show the witness beforehand how the voice distorter works, so that he or she has that sort of confidence that the voice would never be recognized. It always sounds like an alien voice. So the procedure is simple, that when you approach the chairperson or the commissioner, depending on the circumstances, is to first show objective violence and fear. In other words, the human resources manager will testify how many people were assaulted, houses burned, and all of that. Nothing serious in terms of what happens in strikes. So you would have all of that, and then you will say the witness will testify about people coming forward and coming to complain, but refusing to come forward. That's the first stage. Then the second one moves into the subjective test, where the employee may then go to the commissioner, provided you've passed the first test, and say, explain the employee's personal fear, and say, you know, I live in the same, I live 2 blocks away from the other people who's now been charged. Our kids go to the same school and the like, and I fear for my personal life, and I've heard of X, Y, and Z. And on that basis, you satisfy the chairperson or the commissioner for the need to call the witness in camera. And then once you've gone through those processes, the witness will then proceed to give evidence and identify the culprits. But just follow Dielkraal. It's fairly simple. What I see Sean is there. He'll just send you a note how to do that.
Sean, you'd like to proceed?
Thanks, Avinash, and thanks, Hugo. In terms of disciplinary processes, the starting point here is that gone are the days where we are running disciplinary hearings like a criminal trial. There's a host of cases that are effectively saying we need to decriminalize our disciplinary processes. Legally, the bottom line is we need to comply with item 4 of Schedule 8 of the Labour Relations Act, which states we need to tell the employees what they're being accused of, what are the charges per se, allow them an opportunity to state their case. Their case must be considered duly by the employer, after which a decision must be communicated. So it's always going to be dependent on the nature of the strike, the nature of the misconduct committed, etc. But we, by no means, as a general principle, need to run a formal criminal-like disciplinary process. Often what happens is, you know, after a very big strike and the evidence has been captured, the employer would issue charges, locate a venue, and allow the employees to elect representatives to come and explain before a chairperson why their members ought not to be dismissed. The employer will have a representative and a decision will be made. There is scope to suggest, depending on the severity and the complexity of the misconduct, that it could be done in writing as well. There is cases that suggest that asking for submissions in writing is still compliant with item 4 of Schedule 8, because that opportunity to state your case is still allowed. But again, fact specific. The last point is, this is where the importance of your ultimatums also come in. So when you're issuing ultimatums during a strike where there's misconduct, we need to always build in that item 4 of Schedule 8 to state you are participating in an unprotected strike, you are committing various acts of misconduct, you may give written submissions to convince us why you view your conduct as protected and why you ought not to be dismissed or issued with a final written warning. This is the person you must submit these submissions to. This is the time. And in your further ultimatums, you can give more opportunities, so that when you get to a disciplinary sanction stage, you've already set the stage to say, we've allowed them 3 or 4 opportunities to state their case. Again, it is always fact specific, but the bottom line is that we do need to decriminalize our disciplinary processes. Thanks, Avinash.
Thanks to both of you for extremely clear and succinct explanations of those points. And it's going to be very interesting to see, as a follow-up to Hugo's points on in-camera evidence, how technology and the new way in which we are operating might make this even more flexible going forward. I mean, I think of, was it Siemens technology a few years ago, where it was at that point, I suppose, still quite a big deal that evidence was being given from Australia or wherever it was. And we look at now what we can do with technology. We look at court processes happening via Zoom or Teams, and you think about the type of voice changing software or face changing technology that can use to further protect witnesses. Perhaps there's something coming down the line that's going to improvements. Ladies and gentlemen, we are bang on time. If I can ask you to enjoy a 10-minute break, and we'll resume at 5 to 12 with the final session. Thank you. Welcome back, ladies and gentlemen. Hope you had a nice short break. Protection of personal information has become another hot topic following recent global and national data breaches and the implementation of legislation placing a deadline for compliance. Mr. Thabang Rapuleng will deal with POPI in the context of the employment life cycle. Thabang is a director in our employment practice. He has experience in employment law, both as a practicing attorney and in-house legal counsel. He also has experience in industrial relations across Africa, including in South Africa, Botswana, Mozambique, Zambia, Zimbabwe, and Tanzania. Over to you, Thabang.
Thank you, Avinash, and good afternoon. I will be touching on the interaction between POPI and the employment life cycle. So during the pandemic, the COVID-19 pandemic, on the 1st of July 2020, POPI came into effect. POPI brings a new dispensation for employers and employees alike, in that it introduces obligations on employers and grants rights to employees in an attempt to reach a balance between the right of the employer to conduct a business with the right to the privacy of its employees. So in essence, employers will bear increased liability for the conduct of their employees insofar as personal information is concerned. Employers have 1 year to prepare for and take steps to mitigate the risk against the consequences of non-compliance with the Act. So from the 1st of July 2020, we've got a year to make sure that you've got everything in place to be compliant with the Act. I will be talking through the effect of POPI on the employment cycle. We will be looking at what is personal information and the various stages in the employment cycle. Maybe the starting point is to answer the question, what is personal information? Personal information is defined as information which is about a living identifiable person, and in the Act it's referred to as a data subject. The information has the person as its focus or is otherwise biographical in nature and identifies a person. This will include in general in the workplace information about salaries, bank accounts, emails about an incident, for example, individual employees' personal files. And the employment cycle can essentially be summarized into 4 stages. The first stage being the engagement stage, the second one being the onboarding, induction, and training stage, and then the day-to-day management stage and the termination of the employment relationship. So we will be looking at the effects of POPI on each and every one of those stages that I've mentioned. Now let's look at the engagement stage. Well, the example of personal information in the engagement stage will include the CV that you will receive when a candidate applies for a job, copies of their identity documents, the application form itself, the information contained in the application forms itself, background checks, psychometric tests, information, and basically all information that is needed to process the candidate's application. And job candidates will be required in terms of POPI to provide consent for the proper processing and handling of their personal information. And in terms of Section 26 of the Act, it prohibits processing of personal information of race, ethnic group, health, sex life, criminal activity, trade union membership without any consent. So what does this mean? Practically, it means for the recruitment process, candidates must give consent at the very onset during the application process. Now, does it mean that if a candidate was to progress through the recruitment process, they should consent for each and every stage of the recruitment process? My view is that the initial consent that you will seek from the candidate must be structured or phrased in such a way that it grants consent for the entire recruitment process, meaning for the various stages in the recruitment process. And it might appear that it will create a cumbersome task exercise on the employers, but if one looks at it practically, it does not really do so. because as things stand currently, you have to seek consent to conduct criminal checks. You have to seek consents to where the employer needs to conduct to verify academic qualifications and credentials. So that kind of consent is already being sought even before POPI came into effect. So it basically now means you build in your processes now to seek consent upfront even during the recruitment process, all right, when the candidate applies for a position. Now, you may require, you may also require consent to process the information from the date the candidate applies for a job, you know. So meaning now, practically, how do you go about it? Well, the suggestions that we can come up with is, for example, on your career portal, it will help if you were to have the option for one to consent for the processing of their information in line with POPI. But also in the application form itself, you can then build in a section that will provide for consent or will provide a candidate to give consent for the processing of their information. And consent can also be sent through emails and so on. So there's various ways in which you can get consent, but it's very important that we make sure that we do get consent when we are dealing with candidates, job candidates. Now, let's look at the issue of now onboarding, which is the second stage of the employment life cycle. The examples of personal information on the onboarding process will include the contract of employment, for example, the medical aid details, the pay slips, tax records, the bank account details of the employee. The signing of the employment contract usually makes provision for consent to process personal information. But obviously, it does not mean all employment contract templates have that section provided for. One will have to now review your own documents to make sure that that section is provided for where you seek such consent. And you will require, you will also obviously require candidates, employees who were in your employment before POPI came into effect to also consent for the processing of their information going forward. And it's something that employers will need to review to check whether have they sought that kind of consent. Employers, insofar as information such as race and gender, and for the purposes of the employment equity statistics, the employer does not need consent to process that kind of information because that's the information that you are requiring to comply with the provision of the Employment Equity Act. So there's no need to consent, to seek consent for such information. But other information such as, you know, education, health status, which might be relevant for the particular position that the employee is occupying, you will definitely need consent to process such information. And it does happen practically for an employer to also require personal information to enable the employee access to the workplace or to some of its systems. For example, if one thinks about things such as biometric systems in the banking sector and in the mining sectors, you do need that kind of information. So you need to make sure that you require the consent of the employees to register their details on a biometric system. And upon the termination of the employment, the employer will be required to delete or destroy the employee in order to de-identify the employee as soon as reasonably practicable. So basically, the information in the biometric system will be relevant insofar as the person remains in your employment. But as soon as the person leaves your employment, then you need to make sure that that information is terminated. And that is to avoid finding yourself contradicting the provisions of the Act. If we may go to the next slide. Now we will be looking at the day-to-day management. Now, how POPI comes into effect on the day-to-day management or the day-to-day relationship with employees. For example, one can look at the screening records in the context of COVID-19. Yes, one will qualify the context of COVID-19 to say, well, because we are complying with the regulation, we are complying with the provisions of the law, you don't really need a consent in line with POPI. But if one looks at employees' information such as disciplinary records, medical certificates, if you want to conduct drug and alcohol tests in the workplace, performance reviews, employers will be required to appoint an information officer to make sure that there is compliance with POPI. And the question that might arise is what happens if the employer is not a big employer and they're not in a position to appoint an information officer. And our view will be, in that case, the accountable person will have to assume the responsibility of the information officer. But POPI will apply regardless of whether you are a small employee, you are a small company or not, because the right to privacy of your employees, regardless of the size of the employer, will still need to be observed. And we will advise also that employers will need to revise their HR policies to make sure that they put provisions there to safeguard against the requirements of POPI. You revise the procedures for employees to access information, particularly employees that might have access to information of other employees. You need to make sure that the procedures have built-in mechanisms to mitigate the risk of finding yourself not complying with POPI. And it's important to also conduct a risk assessment in relation to the protection of personal information, taking into account your systems, your processes, and the nature of your business or the nature of the environment in which you operate under. In the case of COVID, an employer is allowed to process the information of the employee who tested positive to comply with the legal obligation, such as reporting to authorities. For that kind of processing, you don't really need a consent of the employee. And in the case of disciplinary actions, one will have to exercise due care insofar as we are now dealing with personal information in the context of disciplinary action. And you need to make sure that it's those people who need to have access to that information, who have access to that information, and that you've all ticked the box in terms of consent. The employer must, in essence, the employer must make sure that personal information of employees is kept private. And it's important to also take note that even personal opinions of employees may be regarded as personal information. And the employer must inform employee if personal information is being accessed for purposes of an investigation, and that will be relevant under the context of a disciplinary hearing. Once a disciplinary hearing or information used and shared by the employee during a disciplinary hearing, that information will become public and may be used without further consent. For example, if the information was shared by the employee during an internal hearing and we now find ourselves at the CCMA stage, at an arbitration stage, such information might be used at the CCMA stage without seeking the consent of the employee. Now let's look at the next stage of the employment life cycle, which is the termination of employment. The employer must retain certain information post the termination of employment. For example, the contract of employment must be retained for a period of 3 years. Arbitration awards and so on must be retained for a period of 3 years as well. SARS records must be retained for a period of 5 years. And disciplinary records must be retained as well, I will say, for an indefinite period. Now, if we may move to the next slides, where we're now looking into the consequences of non-compliance. Section 109 of the Act provides that if a responsible party is alleged to have committed an offense in terms of the Act, they may be issued with an infringement notice. The infringement notice might include a fine, and the maximum fine in terms of POPI is 10 million rands. So the fine will not exceed 10 million rands. In terms of Section 107, it sets out penalties for the contravention of specific sections of the Act, which may result in imprisonment. So it's quite a serious, it has serious consequences for non-compliance. If one looks at the monetary fine that you can attract, but also the fact that imprisonment as one of the penalties that might be triggered in terms of Section 107. One of these is Section 59, which relates to obtaining prior authorization. If an employer wants to share information about the employee's health with, for example, a foreign company, they need prior authorization to do so. And I think it's quite important for companies that find themselves operating in different jurisdictions, where you might find some of your employees traveling to different jurisdictions, and you might want to make sure that they've got the necessary health policies, health insurance policies, and so on. And in that context, you might need to share information about the health status of an employee. You need to make sure that you've got prior authorization before you're doing that, because failure to do that will attract the penalties that I've referred to, which include fines or imprisonment. So that will basically be the extent of my presentation on the interaction between OP and the employment life cycle. I will hand over back to Avinash.
Thanks very much. We've received a couple of interesting questions. I'm going to pose a couple to you. The one relates to existing employees and whether the obligations of an employer are different, or in a sense, can one backdate all of this, and should one adopt the same size approach when it comes to dealing with personal information with new employees as well as existing employees? And the other interesting question is, from the trade union consistently refuse to consent, and how does one deal with that conundrum where the employer needs that consent in order to proceed with the employment relationship?
So Avinash, I missed the second part of your question, of your last question.
Okay, I'll just repeat it. So it would be where a union perhaps encourages its members to refuse to give consent to use of personal information to the employer, and how does an employer deal with that, and can employees be disciplined if they unreasonably refuse to give consent in respect of their personal information?
Okay, thank you. Maybe let's start with the first question, which has to do with existing employees. The employer will still need to make sure that they now seek consent from existing employees to further process their information. And I think it's something that will be it's safer for the employee to make sure that they secure that consent, more especially if you take into account that there might be disciplinary issues that might arise in the future, or you might find yourself having to share the information with other companies within your group of companies and so on. So the requirement, the right to protect the privacy of employees will still exist in relation to existing employees. So POPI will still be applicable, and I guess that's one of the reasons why there is this period of a year to allow employers to be compliant with the Act, is to make sure that you then take care of such issues, such as now how do we deal with employees who came in where you find that in their employment contracts did not have provisions for consent because they've been with the employer for a long period. So it's to address such challenges. On the second question, where the withholding of the consent is unreasonable, one will then say that there will be various ways of dealing with it. One, it would be, for example, you can say issue an instruction to the employee to say, well, if this is required for us to be able to for you to be able to work and render services, for example, where it's required for a biometric system, it's necessary for you to have access to the biometric system, but if you are withholding the consent, then it can trigger either a misconduct issue where now we issue an instruction and your failure your defiance of the instruction can result in insubordination, but it can also render some of the employees incapacitated to perform their functions. So it will depend on a case by case. So one will have to look at a specific case of that you are dealing with, but one can say because we are complying with the provision of the law, it cannot be that the unions can simply say we don't want to comply and it ends there. The employer will still have rights to exercise either using the disciplinary code or relying on the incapacity process.
Thanks for that, Tabang. I mean, one of the other questions makes the point that it wouldn't really make sense if we're dealing with a incapacity due to ill health inquiry and the employee says, well, I refuse to give consent to discussing my health situation. I mean, that's what the entire process is about. So perhaps you could share your thoughts on that. And then I was also very interested in what you spoke about. I mean, the importance really of including all of these clauses in contracts. You said it's not such an onerous matter, and possibly then there would be resolutive conditions that if employees have agreed to checks being conducted, etc., and the information discloses something that then comes out of the woodwork, of course, it could lead to the termination of their employment. And finally, I suppose I was interested just in what happens on termination of employment. If I understood you, there's a strong sense that the employer should then not retain the info. So I just wondered whether there was any guidance in terms of the period where an employer would be advised to retain some of the information, perhaps without being in contravention of POPI. Thanks.
Okay, thanks. Let me start with the last one, Avinash. So in terms of information such as the contract of employment, information about the SARS records and so on, you must retain those even post-employment relationship. And the period ranges from a period of 3 years, but for SARS records, it's a period of 5 years. And for information such as the disciplinary record and so on, it can be an indefinite period. So there is certain information that you can retain, but information such as the information that you will have required to give employee access to a biometric system, and the employee is no longer in your employment, then that information must be terminated or deleted, and within a reasonable period. I will say, just do it with immediate effect to avoid a situation where you fail to do it. Now, if we now go to the other example, the other issue that you raised, where an employee in a ill health incapacity refuses to grant such consent. Well, one will imagine that by the time you get to that particular stage, the employee would have granted consent even before for you to process that kind of information. But now let's say we do need consent from that particular employee and there was no consent granted previously. Obviously, it frustrates the process. And I think there's going to be quite interesting case law developing from such situations, because it will frustrate the process. The employer has initiated a process. It's an ill health incapacity process. The employer needs to access your ill health records, and you are refusing such a consent. It will frustrate the process, and it might result in the employer now saying, what other alternatives do we have not to proceed with the process? Because at the same time, you cannot say we will simply proceed in contravention of POPI if we really don't have a consent. But what other measures does the employee have to deal with such a case? And it will be to look at other measures to terminate the employment relationship, if that's the ultimate goal, to terminate the employment relationship without undergoing an incapacity process. Or an ill health incapacity process. So it's going to be quite an interesting one. It's going to be quite an interesting development. And I guess as we deal with these cases, it will become clearer what will be the position of the Labour Court and the other courts in dealing with these cases. But one will say, one will have to always keep in mind that you don't want to find yourself in contravention of the Act because you are saying the employee is refusing to grant consent. You would rather make sure that you are still acting within the ambit of the Act, but then you also then say, what can we do now to still achieve the goal that we need to achieve in light of the fact that the employee is refusing to grant consent? If I may check, Avinash, I think there was a third issue that you raised. I am struggling to recall what was the third issue.
I think it's fine, Tabang. I think you've dealt with, and I think you've made the point also, which responds to a further question that we've received, just that really this can't be now a technique or a tactic that can be used to avoid employers taking reasonable disciplinary step against employees. So I think you've clarified the position, and thank you for sharing your expertise in that regard. Ladies and gentlemen, we are drawing towards the end of today's webinar. Our final substantive slot deals with termination of employment, supervening impossibility of performance, force majeure, and reciprocity. Mr. Adil Patel needs no introduction and remains national head of our employment practice. Adil is a highly respected thought leader in his field and nationally recognized for his in-depth expertise in employment law. He's worked across multiple jurisdictions in Africa and globally, acted as a judge of the Labour Court, and has presented and published on a wide array of topics. He's joined in this session by Andy Besaidenout, a senior associate to the practice, who has advised both local and international clients on aspects of South African employment law. Thank you, Adil and Andy.
Good afternoon, everyone. Today we will be speaking to you about 4 specific judgments and provide some practical tips as to how they operate in practice and what their implications are for you as well. Adil and I will be presenting this part of the presentation together, and we'll be discussing each judgment as we go and hopefully provide some practical tips. The first judgment is the judgment of Swissport SA, and in that matter it concerned 2 specific employees, the one being a baggage driver and sorter, and they were all regulated by the Airports Company South Africa. Essentially how it worked was the Airports Company South Africa could dictate to its clients what are the terms and conditions for entry upon its premises, and at any time it could revoke the permit for entrance. These 2 employees then attended work on one specific day, and there was an inclination or a suspicion rather that they may have been intoxicated, and for that reason AXA refused them entry into its premises. They were then unable to perform their duties, and they had to return or leave to go home. What the employer adopted an approach in terms of which they told the employees that it's their obligation to try and sort out their permits, because it allowed for an appeal process during which they could then inform AXA as to why they may have been incorrect in revoking their permits and then granting their permits to them again. So it was ultimately a case of supervening impossibility, because without these 2 employees being entitled to access the AXA premises, the Airports Company South Africa premises, they were unable to perform their duties, and for the period of time during which they were unable to access the premises, they were also not paid. Ultimately, the employees did nothing to revoke their permits, and the employment was terminated on the basis of supervening impossibility. The matter was challenged, and the fairness of their dismissal for supervening impossibility was ultimately challenged, and the CCMA initially granted them compensation, but that matter was reviewed at the Labour Court. And the Labour Court was of the view that in this case the employer did in fact act correctly, because it's regulated by its client's terms and conditions of employment, and it was not in a position to dictate to AXA what its entry permits should require, or why these employees should in fact be allowed. It's specifically relevant to the court in this case that in order for Swissport SA to render its services, it required access to AXA's premises, and it was a requirement of the position that these employees be entitled to access the premises at all times. For these reasons, the Labour Court in fact agreed that the dismissal of these 2 employees on the basis of impossibility was in fact fair.
But I think, Andy, what's important about this case, and just going forward and having come out of COVID-19, is how do you discipline somebody, or how do you deal with this where employees are unable to render services? The first thing we must accept is you must provide them with a right to a hearing. You must allow them to be heard. It's the way in which you get them to be heard that is operative. So some employers are saying, well, where employees are unable to work and we want to terminate their services, because we'll talk a bit later about where we not going to pay employees because they are unable to work, but where we want to terminate them, we need to go through this elaborate disciplinary criminal trial process. And our view certainly is simply this here. You are not going to find in Schedule 8 of the Disciplinary Code and Procedure a sort of criminal method of holding a hearing. And all you need to do in circumstances of this and other circumstances is simply to write a letter to the employee. Please make written representations as to why your employment should not be terminated as a result of you not having the requisite credentials. Let the employee make whatever he or she wishes to, provide whatever documents they want to, and on the basis of that, take a decision to terminate the employee's employment. Give the employee the right to make the representation so that you can tell an arbitrator or a judge that you afforded the employees a right to a hearing, and that right to a hearing was done on paper, which is fairly acceptable by our courts. Anli?
So that very point, Adil, was also considered in the judgment of solidarity armaments. And what that judgment concerned was an employee who was employed in the Defence Force, and the employee in fact had 30 years service. And what happens in the Defence Force is they get allocated certain security clearances, which they are required to retain and maintain for the duration of their employment. So this employee's contract of employment required the employee to maintain and retain a certain level for the duration of their employment. But also the Defence Act said that the employer is not entitled to employ an employee without that necessary clearance certificate and to retain that employee in employment. So it was essentially the contract of employment as well as the legislation having these minimum requirements. The employee after 30 years reached a certain level for which you're required to apply for a renewal every now and again, and the employee did so. Without any reasons being provided to the employee, the renewal was not granted, and the employee did not in fact receive the required level of clearance. And the employer adopted quite an interesting approach by writing to the employee and saying to the employee that essentially, because of the contract of employment as well as the Defence Act, this employee's employment is then terminated. No reasons were provided, and the employee was also not provided with an opportunity to make representations as to why he should not have been dismissed. And what's interesting is because he had no reasons, he didn't know what to say or what representations to make in any event. And what the employee then did was he appealed internally and at the same time referred a matter to the CCMA stating that he had been unfairly dismissed. The matter proceeded all the way up to the Labour Appeal Court. And the Labour Appeal Court said, made quite an interesting point, and they said that incapacity can flow from any condition that prevents an employee from performing work. And it's a species of impossibility. So they almost look at impossibility of performance as a form of incapacity. But they said in this case, what bothered them most was the employee had no reasons provided to them. And the Defence Act actually required you to provide the employee with an opportunity to make representations or for that decision to be reviewed. So in a case such as this, although the contract as well as the Act may have prohibited his employment, he should still have been provided with an opportunity to make representations, and in order to do so, he should have had the reasons for why the employer was of the view he could no longer be employed. And on that basis, his dismissal was found to be substantively unfair.
Because I think what was interesting in this case as well, one of the factors that the court's taken into account was that he could have occupied a position which does not require him to have those necessary credentials. So had the employer allowed the employee to make those representations, the employee would have said, that's fine if I can't occupy the position which I am employed for, but please consider whether I could be employed as in any other position. And it's that ability to look for alternatives even when employees do not have the requisite qualifications and experience or credentials or permits that one has to investigate. But I think what is important from both of these cases, and it is something that our firm has continuously advocated, it latches onto this concept of the decriminalization of our employment law space. And anyone that has heard us talk is probably tired of us saying this. We need to stop treating the employment relationship like a criminal trial. If you come from my era, like it's not LA Law, it's not Ally McBeal, it's not Suits or anything of the sort. It depends which era and whether you're a millennial or a baby boomer or the like. We must stop calling people accused, prosecutors, chairpersons and the like. So while the Almonds Corporation had the right idea of asking the person, of sending a letter, they sadly had the content incorrect. Anli?
That takes us then to the CCMA ruling in the KitKat matter. And this is also a question we get asked a lot, where employees get arrested for whatever the transgression may be and they're unable to return to work. This is a CCMA ruling, but these two employees were arrested for fraud at their workplace and they were then released on bail. But one of the interesting conditions that the magistrate placed on their bail was that they're not entitled to contact any employees or colleagues during the period for which they're out on bail. So the employees were then also not paid for this period. And what happened was the employees referred a dispute to the CCMA as an unfair suspension dispute. And the unfair suspension dispute came before a commissioner just for the employees to admit that they had in fact not been suspended. And the employer then argued, well, they haven't been suspended and they're also not entitled to pay because they can't work. And this is of no cause of the employer because the employer did not impose the bail conditions. And the CCMA commissioner agreed. They said that the reason the employees are unable to perform their work arose from a decision of a magistrate, which had nothing to do with the employer. And for that reason, the employer was justified in not paying its employees during this period and then until they were able to return back to work. What's also relevant in this case is that the employees, in fact, after the case was withdrawn against them, never tried to return to work in any event, and that was also noted by the CCMA. We then move on. Yes.
The next slide, please. Thanks.
We then move on to the LAC judgment dealing with reciprocity. And this is quite an interesting matter where the employee was employed as a programmer and he had been for quite a while. And what Kajima did is they implemented a retention bonus scheme in terms of which they would pay their employees at the beginning of the year in order to retain them in the employment or to motivate them not to resign for a set period of time. So the court accepted that principle that this retention bonus scheme could be that you pay up front or you pay at the end of the year, but the purpose of that scheme is to keep an employee in employment. For various reasons, the decision was made to withdraw the retention bonus scheme, and the employees were informed of that. And this specific employee, in fact, took issue with that and challenged that decision. Ultimately, that decision was reviewed and it was decided that employees will nevertheless be paid their retention bonus scheme for the last year of the scheme, or that the scheme is in place, which is in September of the year. So in September of that year, they paid the retention bonus only for this employee to then resign in October of that year. And in paying his last salary in November, the employer then proceeded to deduct his retention bonus payable to him, or that was paid to him in September, from his final salary. The employee referred a dispute to the CCMA, or to the Labour Court rather, that then proceeded to the Labour Appeal Court. And the basis of his claim was that he should have been paid the retention bonus. He did not set his claim as a unfair deduction dispute, which is quite relevant because that's the nature of the dispute to which they tried to change it towards the end of the proceedings. And the court considered this principle of reciprocity, and it looked at the retention bonus scheme and its wording specifically. And it said that in these types of contracts, one performs in expectation of the other performing. So in other words, it's reciprocal if there is an expectation that I will perform in order for you to perform your part of the contract. And in this instance, the court accepted that the retention bonus was specifically paid to the individual in return for the individual committing to the performance of his contract for another period of 12 months. And in not doing so, they were fully entitled to then deduct that amount and to withhold that amount from his final salary because he had breached the obligation which he had in terms of reciprocity.
Then the next slide, please. So I think while you are thinking of those interesting questions, can I just bring all of this to home? We've had COVID-19, we have had level 5, level 4, level 3, 2, and now 1. And I can't even remember level 5. It seems like a distant memory to me. We were on our phones 24/7 trying to decipher what to do with employees who are unable to work as a result of the pandemic. And this was the crux, and people were using contractual terms like supervening impossibility and reciprocity and impossibility of performance and the like. And everyone jumped onto the bandwagon. Everyone said, we refuse to pay our employees because the president has put us down to level 5 and he has no right to, and we as the employer can't pay our employees. And then we had a host of academic articles and everyone was just confusing each other. And then the Labour Court came in one of the judgments that are not mentioned on the slides, and they say the following to you. Sorry, you were able to work in level 5. Some of you certainly were able to work. If you look at the industries, you were able to work and therefore pay your employees. So the point is, if government intervenes and prevents you completely from working, hairdressers couldn't work during level 5. So there you could argue that I'm not obliged to pay you. But where in an industry you are entitled to work even in level 5, you were nevertheless required to pay employees. And what was interesting, colleagues, was the following. People were saying that because of level 5 and which of any other level, we don't have to pay people severance pay, or we don't have to pay people notice pay because we're in a pandemic era. And they were using, I had CEOs and CFOs and HR practitioners telling me about reciprocity and supervening impossibility. And the reality of the matter is, irrespective of what is happening to your business, if your business is able to operate, even though the level of work that you have has substantively reduced because of the pandemic, that's not your employee's problem. You must pay your employees their salary if your business is open. If you put them on temporary layoffs, you must pay them their notice pay when you retrench them. It is not their fault that there's a pandemic. It is not their fault that your business cannot operate during a pandemic. It is certainly not their fault that the level of work which you have has substantively reduced. So employers were now saying, oh my word, we're in a financial crisis. We want to reduce employee salaries. And they tried to use contractual principles. And we forgot what they taught us at universities and what life had taught us. That you want to change the employment contract, you want to change the terms and conditions of employment, you obtain the employee's agreement. So employees were just were just simply reducing employees' remuneration and saying, no, it's because of the pandemic. Like the pandemic was this magic wand which got rid of employment law as such. You want to reduce your employees' salaries because of your operational needs. The law hasn't changed. You still need your employees' consent. Thanks, Avinash.
Thanks very much, Adil, and set of cases that you weave together, and it's prompted a few thoughts in my mind and a couple of questions that are coming through. And Adil, you've taken us back now to that initial panic, I think, that there was, and almost opportunism in terms of trying to use the COVID pandemic as a get out of jail card, perhaps, if you were hoping to get rid of some of your employees. So I wanted both of you to perhaps just reflect a little bit on that distinction between temporary and permanent supervening impossibility, because there is a distinction there. And linked to that, when you spoke about alternatives in the arms corps case, I mean, I'm just thinking now, how far does that go? We're starting to see employees getting accustomed. I'm accustomed to, put on my jacket and tie, but the shorts are on underneath, or whatever the case may be. Now, how far does that extend from home as an alternative if, for example, they have a comorbidity, or put up a case to suggest that they wouldn't be best served by actually coming to work? Let's start with those.
Only you can answer those really difficult questions by the professor from the Nelson Mandela University.
So, Avinash, I think it always depends. So firstly, you're correct in that you have to do your assessment about temporary and permanent disability, because that assessment really dictates your obligation as an employer. If it's permanent, the future looks very different and the process looks very different to it would have if you are temporary incapacity or temporary impossibility of performance. And that then both links to this concept that we call reasonable accommodation. Now, what is reasonable for an employer to do will always depend on the facts of the matter. And although that sounds like very much like a lawyer's answer, it really is subject to your specific organization, what you can do to accommodate this employee and for how long you can accommodate this employee. And that will then dictate the process that you need to follow, and at which point a temporary incapacity may in fact have become a permanent incapacity.
Thanks very much for that. That certainly clarifies it. And I think, Adil, you've also clarified, because we started seeing some judgments. I think Max Steel was the one where it started talking quite strongly about the no work, no pay principle. So it's interesting, how, in a sense, you've reminded us that there's a balancing that needs to take place. Employees still have rights. I mean, we've spent quite a bit of time today explaining ways in which one can deal with discipline and dismissal of employees or retrenchments in a fair way, but in a properly transparent but truncated way. So I think that's an important balance. The other question that we've received is about supervening impossibility of performance in the case of an employee who loses their work permit. And this is something now that the employer can't be saddled with. How would you proceed in that case?
And I think that we've got established case authority there, right? So what you need to do is you need to hold a hearing or make written representations, give the employee an opportunity to be heard, and then terminate the employee's employment. And there's at least two cases. The one is discovery, which says the fact that you employed somebody without a work permit does not, although you may be criminally responsible, does not detract from the fact that that person doesn't have employment rights as such. So you may be able to terminate the person's employment, but what you need to do is to assist the employee, and more than that, allow the employee to be heard. Once again, you don't need an elaborate disciplinary process. My final point on this before we close is I've heard some interesting questions where where employers are saying, now with remote working, employees do not have access to Wi-Fi at home, and therefore that's a supervening impossibility. And if you were born after the year 2000, it may be, but the reality of the matter is you as the employer must ensure that if you tell your employees do not come to work, make sure that they have the necessary tools to work from home. And this sort of thinking is going to impact upon us more and more as we move. We've been catapulted into the fourth industrial revolution. We are made to think about, and our topic about supervening impossibility, reciprocity, working from home and the like, is going to require us to think about how do we manage our employees. So if we start focusing on bums on seats and not on the delivery of a product, we're certainly going to fall short, because I've seen employers investing in fancy technology just simply to monitor whether an employee has logged onto a system, irrespective of whether they're doing any work or not. We need to start changing our mindset, colleagues. And these things about supervening impossibility, reciprocity, how we deal with discipline, needs to be encapsulated in our context of employment, needs to be encapsulated into our policies and procedures. But most importantly, we need to start thinking differently about work and what it means and how we monitor and what we monitor. Thanks, Avinash.
Thanks very much. Anli, any final words from your side?
Nothing else from me. Thanks, Avinash.
Thanks very much. And Adil and Anli, you've really wrapped it up and brought home precisely this concept of the changing world of work, which is of course the theme for today's webinar. And also, I think, spoken about how it's not just about the paperwork, the contracts, the formalities, and something we touched on earlier this morning, that how organizations survive and are able to survive and respond to what has been an incredible global event is going to boil down to more than just the dotting of the I's and the crossing of the T's in terms of the paperwork, but it could potentially involve, depending upon how that organization is operating, an actual mind shift change, a development of a new organizational culture, one that gets that balance right between monitoring the performance of employees and setting the right minimum standards, but one which is flexible enough to allow for the types of common sense, practical workplace arrangements that will allow the employees to thrive and be an asset to the organization and allow that organization to survive in what is going to be an incredibly challenging labor market going into 2021. Ladies and gentlemen, I'd like to take this opportunity to thank you for spending the time with us this morning. It's been my pleasure to facilitate the session, and we'd like to close by giving our National Practice Head, Mr. Adil Patel, the final word to conclude and offer his remarks on the year under review. Thank you very much.
Thank you, Avinash, and thank you to all the speakers, but more importantly, thank you to all participants. This webinar could not have been made possible without the assistance and coordination of our marketing department, and in particular Karushka and Heidi, who we thank immensely for, and our IT support, Ralph. The new world of work requires people like Ralph, Karushka and Heidi. Without that, we will never be able to deliver the service that we are to you. And as we move into the new world of work, what is becoming more and more important are people that understand the legal market. And our firm has taken a definitive decision to have professional services lawyers who are solely dedicated to ensuring that you as a client's needs are met from an information empowering perspective. And in this regard, you would have met Riola Koch and the Professor Avinash, who are there to assist us in delivering the material and information to you so that you do not have to be paying for vanilla advice. We want to ensure that publications, guides, information booklets are made available to you so that you can empower your colleagues and come to us for sort of the bespoke sort of advice. This is the way of the future. This is the way of the fourth industrial revolution. This is what COVID has taught us. Going forward, please look out for our various e-learning products, because we are unable to meet in person any longer. And if any one of you have met me before, you would know that we were prepared to come and meet with you for free if you gave us a good cup of coffee. Well, those days are long gone, and so thank you for joining us. We're now at 12:50 and we hope you thoroughly enjoyed this. Please look forward to receiving our booklet, which will be made available shortly to you. Thank you all. Goodbye.